here and 12.
12. It's a thatched structure, my lord. Nothing much to demolish.
Friday,
Friday আসতে পারবি?
14th.
এই ফ্রাইডে আসতে পারবি? আজকে কবে? আজকে কি বার? মিলন 1 মিনিট। আজকে বুধবার, বৃহস্পতি, শুক্র, মানডেতে আসবে। মিলন মানডে উইল ইট বি
Monday is 17th, so I have to stay the order in that case.
No, Friday, your lordship keep it on Friday. Let us try.
Friday.
Let us try.
Provisions have to be followed.
Yesterday only we have got this received the brief,
Come back to the instructions.
right?
It is submitted on behalf of the petitioner
আনতে পারবি তো?
that though a coordinate bench of this court, comma, by an order passed on 10th April 2023 in WPA 8422 of 2023, comma, directed the subdivisional officer Tehotto subdivision officer, comma, Tehotto subdivision, to dispose of the allegations of both the parties with regard to encroachment over government land in accordance with law and in terms of the Act of 1962, comma,
আসতে চায় না এরা।
provisions of the Act have not been adhered to by the respondents in passing the order impugned on
There are
6 June 2023 is the order.
My lord.
6 June 2023. Stop. The said order is assailed in the writ petition.
জনটা কোথায়?
Learned counsel for the petitioner submits
77
that no notice under section 3 of the Act of 1962 was served upon the petitioner prior to the hearing, and though the petitioner submitted an application for adjournment of the hearing on medical grounds, comma, hearing
এখানে শোকজ নোটিশ দেয়া
was conducted
শোকজ নোটিশ
in absence of the petitioner.
এটা তো
on the
কোর্টের
relevant
অর্ডারে আমরা
date.
অ্যাপ্লাই করছি শোকজ নোটিশ দেয়া
Paragraph. Learned counsel for the respondents seeks to take instructions in this matter. Paragraph. Let the matter
এখানে
appear
না
under the
দেখে
same
বল-
heading
না
on
পড়ে বলা
14
যাবে
July.
না। Dear lordship is fixing it on
You
7th.
have not filed your affidavit of service.
My lord, the affidavit I handed over.
Oh, yes.
Friday,
I
Friday.
think- I'm sorry. Affidavit of service, none appears for the
পঞ্চায়েত। তাকে ডাকতে হবে।
for respondent numbers 3, 4, 5, and 6. Despite service.
Not your lordship is fixing it on next Friday.
This Friday, day after
This
tomorrow. Because 17th is the date for demolition.
Let us go. Grateful to
Deeply obliged.
Item 2,
I think I am for the petitioner. This is all our identical matter that we have sand mining operation. Your lordship earlier occasion directed to submit a report to the state authority. Just now I have received a copy. So my lord, kindly allow me.
You want to go through the report and come?
Today I have received it.
Similar matters have been disposed of
But
already.
one prayer before your lordship. I have deposited money, lump sum money in the year of 2018. Due to national order, due to order of the Green Tribunal, they could not execute the lease. Just now I have come to know, my client has stated that it is already banned, has been lifted. So my lord, I am not sure if it is banned, lifted, kindly.
Bank has been, I could not follow you, I'm sorry.
That is imposed by the National Green Tribunal not to lease out any property, any.
Yes, yes.
Due to.
That
without
ban
the
was
order.
lifted, isn't it?
I have just heard it, but I am not sure. It is, they can ensure that whether it is correct or not. So if it is lifted, my lord, so my.
There is no any ban, there is no any
I am
nothing else
very
is there.
happy to lordship.
There is
At
nothing. but-
present, I don't think there is any ban.
No, my lord, there is
That was
nothing.
lifted earlier.
Earlier,
Yes.
then my lord, so my lord, humble payer making appeal to your lordship, they have deposited money to do the business. And if your lordship direct to refund the money with 5%, it is not. On that impression, they did not submit the money. So I will kindly direct them to consider my application so that I can continue my business. It is only because money is lying with them. I do not want to refund back my money.
My lord,
I have already annexed it.
my lord, in my application, my lord, I have annexed page 13, my lord,
Page 48.
Third.
My lord, kindly page 40. This is
Oh,
my
sorry.
application. They have annexed it.
48, my lord. I also annexed.
3rd February 2022, 20, I made an appeal. Kindly allow me to do my business. So, my lord, my humble prayer, making appeal to your lordship, direct the authority to consider my prayer because they have deprived so long. They have not earned anything. 5%.
Page 48.
Page 48. That application they have already annexed.
We are also annexing that application, my lord, in my.
You have asked for shifting the location,
It's
is
not
it?
shifting. It is over.
Now it is
Whatever problem was there, it was over. So, my lord, I am asking, I am praying before our lordship. Kindly direct them to allow me to do the business.
not
so
allowed
that-
to consider.
To-
Not allow, my lord, that is a very.
That means consider means kindly visualize the position. Last 5 years, money has been lying with them. I could not do the business. Only 5% interest is not so sufficient. So, my lord, kindly allow them, direct them to consider my application on the sympathetically so that the client can recover their loss, whatever they have sustained, and do the business for 5 years. And
So will you consider this representation
ma'am.
without wasting further time?
Yes, my lord. Yes, my lord, I must consider.
We-
I request my learned friend to, that
kindly
we
give
must
some
consider.
observation because he has already suffered some long. So, my lord, we kindly allow
But
them,
there is no
direct them
position on any observation.
to consider my application so that I can continue my business. Lease can be executed and do the business. Only appeal for that portion. Otherwise, simple, they will not at all consider, they will reject it. Because the situation is totally different. I deposited money and money was them with them. I wanted to do the business. 5% interest is not the sufficient, Lord.
That is
But
the
fine.
order of the Supreme Court, my lord, we are not.
I'm not disputing that. Supreme Court has the order. But now, at that moment, that a banned order was there. That's why other matter, your lordship directed to refund the money. I also wanted. Just now I have come to know that ban has been lifted, so there is no problem. They can execute the lease in favor of me, my lord. Only direct them, when the ban, if the ban is lifted, they can consider my application.
Because, Mr. Dev, you say in your report that the auction is still operative.
Yes, my lord.
It has not been terminated. So that will be a better opportunity to consider.
Yes,
the-
my lord, I told him
Yes,
that
it has not been terminated till now.
I'll record that.
I'm getting.
The report in the form of affidavit submitted on behalf of the respondents is taken on record. Paragraph. It is not in dispute that being the highest bidder in the e-auction floated by the respondent authorities, and on payment of 1/3 of the total bid amount. You have paid 1/3 only, isn't it?
Entire amount I have.
Bid amount
Entire bid
and
amount.
upon payment of the entire bid amount, 1/3 now.
I have annexed it, my lord.
And upon payment of the entire bid amount, letter of intent was issued in favor of the petitioner. By the authority. Paragraph. It is contended on behalf of the petitioner that the petitioner was unable to that the deed of lease could not be executed in favor of the petitioner due to ban imposed by the Honorable National Green Tribunal upon execution of upon grant of mining lease. The petitioner initially prayed for refund of the amount deposited by her before the, deposited by him before the authority. Stop.
Because there was a banned order, that's why.
Paragraph. Learned counsel for the petitioner submits that since the ban on
September,
mining operation has been lifted by the National Green Tribunal, tribunal, and the petitioner is eager to commence mining operation, and also, since a huge amount of money deposited by the petitioner is lying with the authority, the petitioner,
70 lakhs 10,976.
a huge amount of money to the tune of rupees 70
lakhs 10,976.
70 lakhs 10,976 is lying with the authority, the petitioner intends to, the petitioner is eager to carry on mining operation upon execution of deed of lease by the authority. Paragraph. The report submitted by the respondents indicates that the auction is still operative and has not been terminated as yet.
I'm grateful.
Paragraph. The petitioner has submitted a representation in this regard before the concerned authority on 3rd February 2020 and prays for a direction upon the authority to consider the representation at the earliest and take necessary steps for execution of the deed of lease in his favor. Paragraph. It is submitted on behalf of the respondents that the fourth respondent, is it?
Yes, madam.
Fourth
Additional
respondent be directed to
District Land and Land Reform Service.
consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof.
I'm grateful.
Disposed of.
Thanks.
Next.
Item 3,
My lord, I beg to appear for the petition.
On behalf of the respondent.
Two REIT applications were filed. One with regard to some electricity issues and another is this one. The electricity application has been disposed of by this honorable court long back. These issues, we preferred an application to the block land and land reforms officer at page number 16 for demarcation of
You
one
are
boundary.
appearing for the state.
Private respondent,
For demarcation of boundary.
Private respondent, you have,
my junior.
about the state. Where is your affidavit of service?
My lord, this is the affidavit of service except Pradhan, everyone has received. Pradhan has
Serve the
refused.
Pradhan and come back.
No, Pradhan has refused.
Refused. That's service.
In the representation, there was a prayer. for-
What about the state? Who is appearing?
State, only the state. The copy now.
Mr.
Mr.
Dev, here it is. Please serve a copy of the requisition.
Let a copy then.
Yes, you can place your
Sir.
case now.
So there, my lord, there was a prayer at page number 16 with an representation to the block land and land reforms officer.
16:16.
To the block land and land reforms officer for demarcation of boundary between the petitioners and the private respondents. And thereafter, one attempt was made. Not that they have not attempted, that is not annexed, but I have been instructed. This is the report. There is an attempt
Please
was.
tell me one thing, how is the block land and land reforms officer responsible for demarcating your private land?
No, my lord, there is a dispute regarding the land and one applications before the land tenancy tribunal is also pending regarding correction of record of rights. Still, they are in the position. I am also in the position, but they have encroached certain portion.
This is not government land,
No, this is a private land,
it's a private
private
dispute.
land, private dispute.
So the BLLR has no responsibility.
But they
whatsoever
attempted, my lord. But due to natural calamity,
beyond their
yes, there is a report. They attempted, but due to natural calamity, they could not.
Was that a very legal attempt?
No, not so legal.
Any of the parties must have influenced him.
That's why we have made an application, they attempted.
What is your prayer in the writ petition?
I to consider a representation. To only consider the representation and to just to demarcate the boundary.
No,
Not maintainable. It's a private dispute.
My lord, if they consider and just make an attempt so that unless and until the application before the
That
tribunal is.
endorse an illegal attempt taken.
No,
by
my
the-
lord,
made
that
by the
cannot be.
PLLRO?
But since then attempt was made, that may be some action on their part so that we can leave and they also can leave till the application is disproved of between the
It's not
tribe.
the forum.
And-
You can either withdraw or have to dismiss on this ground.
My lord, we are withdrawing.
There's no punishment. Affidavit of service. Service upon the Pradhan, Kanpur, Ankeria Gram Panchayat has returned with an endorsement, inverted comma, refused,
Oh, we have to copy.
which amounts to, refused to inverted comma, which amounts to good service. Paragraph, none appears for the state respondents despite service. Mr. Dev, who is present in court, regularized court and copy service of action. Paragraph. Learned counsel for the petitioner submits that the petitioners submits that the petitioners do not intend to proceed with the writ petition any further. Paragraph, in view of the same, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph, there shall however be no arrest costs as is certified website court. One more to act.
Item 4, please, Your Lordship, I am for the petitioner, my lord. I have served the state and
Where is your service? Mr. Gangu?
I'm happy.
may I proceed?
সে উকিল চাওয়া শুরু করে দাও।
হ্যাঁ।
সেই উকিল বাবু চাওয়া শুরু করে দিচ্ছ।
Only state respondents? Yes.
Yes, my lord. My lord, I can say with some amount of certainty that there's not much acrimony in this matter. I am a Government of India enterprise. I have a technical services center in Balitikuri, Howrah. And my lord, sometime in 1960-61, land acquisition proceedings had taken place to set up this particular technical services center, which provides vocational training and so on and so forth. Thereafter, my lord, in 73, there was further acquisition for building an approach road, construction of approach road. I paid whatever amount was asked of me. In the 80s, I was requested by the state government to transfer some of this land because 121 acres were acquisitioned and about 76 acres was transferred to the then CMDA and thereafter in 2004 to KMDA with a deed of transfer by me. I have been in possession, my lord, undisputed possession since 60-61. The only difficulty is, my lord, despite inter partes correspondence between the two ministries, because I was handed over the land by the Department of Industries and Commerce, and there have been inter partes correspondence which I have annexed in the petition. Despite this, my lord, there has been no deed of transfer that has been executed in my favor. The ministries have spoken, they have written, they have communicated that yes, we ought to, but there has been some indolence on the part of the government. There has not been any action since the past 40 years.
You're asking for a formal deed of conveyance.
That is all, my lord.
Mr. Ganguly?
My lord, I have got the instruction, your lordship, এই দর্শক এটা দেবেন। দাদা এটা দেবেন না?
Have you served a copy?
No, just instruction. It is not a report. It is just instruction. Your lordship, your lordship will grasp everything. Your lordship can see from the first paragraph. Your lordship can see that. On examination of the records, documents available with the office file, it appears that 121.52 acres of Baltiguri, land of such and such, were acquired by LA case number 4 and 5 under the provision of Act 1984, Act 2, 1941 respectively. But his main query is for deed of transfer. Then your lordship can see that. In both the cases, proposal was issued for the Commerce and Industry Department, Government, West Bengal, for acquisition of the land for construction of Indo-Japanese prototype production and training center at Baltikudi, Moja, Howrah. Then your lordship can see in respect of LA case number 04 of 1961, Notification under section 4(1) of the LA Act 1894 was published in the Calcutta Gazette on 20th February 1958, hearing number 27. Government of West Bengal handed over the position to the petitioner company, that is NSISC Limited, a fact admitted by the writ petitioner. Hence, the respondent number 3 and 4 are not in a position to execute any deed of conveyance in favor of the petitioner company NSISC. Then you will also can see, moreover, it has been submitted. That is para 6, my lord. Though it has not been numbered, I'm sorry, bro. It has been submitted by the petitioner that more or less 76 acre out of aforesaid total acquired land was transferred by the petitioner to the Calcutta Metropolitan Development Authority. Subsequently came the why deed number such and such. The respondent number 3 and 4 were in no way involved in the case. Transfer, you need me to read out the all.
I've seen it. I've
Yes.
gone through it.
That where is that position of transferring the land?
How could you have transferred the portion of the property before the transfer deed was executed in your?
May I,
favor?
my lord, point out how this entire transfer proceedings happened? Because I've annexed all these documents, my lord. My lord would kindly look at page 29. This is when the possession gets transferred, and this is because of the direction from, in fact, my lord, I may kindly request your lordship to look at page 28. This is the direction.
This is not legible.
I'm sorry, my copy is a cleaner copy.
My call. Well, I don't know whether your lordship's office is legible or not. My copies are not legible.
Page 25 is a transfer by you to the CMD or KMD or whatever.
KMDA.
Lordship pleases.
There is no document of your having occupied the land or received.
This is an admitted position. I shall come to that.
It's admitted, but no document.
That is my entire grievance, your lordship. And if my lord comes to page 28, this is a direction flowing from the Ministry of Industry, Department of Public Enterprises. The central government writes, and this is because the state government had requested me to transfer. I had initially transferred occupation, not really. The CMDA was a permissive occupier in the 80s, and in 2004, I was made to execute a formal deed of transfer. Now, my lord, I had been writing to the government since 1980. The government had been playing this bureaucratic football. Land Reforms Department, Acquisition Department says Ministry of Commerce has to consider. Ministry of Commerce says, oh, Land Ministry has to. My lord, I have annexed all this correspondence. So if my lord would kindly look at the correspondence between the ministries from page 51 to 63, that is my entire grievance. I am in occupation of this land because this land was acquisitioned for setting up of this center. My lord would kindly look at page 51. Inter-parties correspondence. I'm sorry, interministerial correspondence.
Approval was granted.
Approval was granted. Page 52, my lord. These ministries are writing that I have requested, my lord, the second last paragraph. In fact, the third last paragraph. The Deputy Secretary, Commerce and Industries, if my lord has found that.
Yes.
This office that the deed of transfer will be required and also requisite to take necessary action towards the deed of transfer. All this is happening, your lordship. And in the middle, I have been pressurized to transfer permissive occupation of this land. Thereafter, transfer this land to KMDA. All that I am requesting for is that this formal deed of transfer, which the government has been dilly-dallying for 40 years, right up to 2018, my lord, I have built up correspondence. And right up to 2018, my lord, with your lordship's permission, I'd want to show one more correspondence here. My lord, pages 61 and 62. And I'm only showing correspondence between two ministries. Page 61, my lord, the district magistrate, office of the district magistrate, land acquisition department, so and so, writes to the LR department, LA branch. My lord, I shall go to 62.
61 is a 61. Yes, 61 is the deputy secretary.
Yes, land and land reforms department, land
Special
acquisition.
area has-
branch. Yes, sir. May I? Sir, my lord, page 62, the first paragraph, it is important to note here that Commerce and Industries Department was the requiring body from whom NSICL, which is the petitioner, admitted facts, Your Lordship, and they are still saying that Commerce and Industries will take this up. My lord, I am not in a position in the middle of this bureaucratic football to really get the transfer of the land done in my favor, and which is why I can't have my name recorded in the record of rights. For 40 years, I've been waiting for this small piece of justice.
Not your prayer, your lordship, can you come to the prayer?
Yes.
A deed in the nature of mandamus, respondent forthwith execute the deed of transfer conveyance of the aforesaid land of Balticudi. How this has been in my instruction already, I have read it over. What is the scope? He has already handed over this.
Handed over on your approval. It was your request and your approval. After that, he has handed over. Please come to page 51.
But my instruction does
23.
not say so, sir.
This is your document.
51 is not legible, your lordship.
Sir, would you mind
কিছু
taking
পড়া যাচ্ছে না রে ভাই।
আপনি আমার copy নেবেন, please? I'm
আমার তো
sorry,
পড়বো
this is
না।
small.
I have to take the instruction. It is of 1983. Letter of 1983. For all these things, but your letters are not available. Whether they have seen or not, I do not know.
All right, I'm serving you this fresh
No,
copy.
no, I shall have to come back with the evidence then. in
Look,
that.
this is the problem. I'm serving my learned
Page
from my learned
51,
friend.
52.
দেখুন না, এটাতে দিচ্ছি আপনাকে
I
fresh
don't
copy.
need.
It was upon your direction, your approval that he transferred to the KMD. So, the government authority has never denied the execution of the deed.
Let me come back with the further instruction, whatever instruction I have read over to my lord. Let me come back in
This
respect of these two
instruction
pages.
is really not very happy.
Lord, what can I do, Lord, your lordship, can you tell me? The instruction, whatever we get the instruction, we say, we make our submission on that, but particularly the pages also are not, available. Otherwise I could have read it, I have seen it. Your lordship, can you see?
You can come back with further instructions.
I will come back with the further instruction, that your lordship can grant me
The
some
court
favor.
has a lot to do.
We'll see that, how far can be done.
There is nothing in dispute in this matter. You have agreed to execute a deed. You say that the department will do, the
Let me talk to
department
the
says that you will
department.
do.
We'll talk to the department.
The
We'll talk to the-
subsequent transfer was made on your approval. So he has not done anything wrong. Only thing is the deed, the formal deed has to be executed.
Let us see.
A very simple matter. Let us not complicate it.
Let
Please
us
come
talk
back
to
with
the,
instructions.
the department concerned, let us see what instructions.
Well, I'm filing my affidavit of service.
Presentation,
Affidavit of
কোনো
service.
representation আছে তোমার?
আছে।
The representation আছে?
Last.
Written Instructions submitted, paragraph, or instructions
Representation.
submitted on behalf of the respondents is taken.
Copy দেয়নি। Because 64, page 64, they can demand justice. আমার representation
petitioner.
আছে from 51 to 63 parties correspondence এর মধ্যেও আছে।
Lord, one thing, may I suggest one thing, or your lordship can direct the authority to consider their representation in accordance with law.
I will
That
not,
also can be
the only direction that I will give, let me share a piece of my mind now, here and now, for execution of the deed. No other instruction.
Then I will come back with the further instruction, not your lordship,
That
can
is
you
why
allow
I'm
me?
giving you time. I'm giving you opportunity. Because here there is no question of consideration at all. Everything is admitted.
Anyhow,
They have to only execute the
your
deed.
lordship, can you
That's
give me liberty, I will come back with this.
all. The petitioner prays for a direction upon the respondents to execute the deed of conveyance in respect of the plots in question in his favor. Stop. The documents on record demonstrate that a portion of the plots has been transferred by the petitioner to the KMDA on approval
Section there.
of the respondents. Paragraph, learned counsel for the respondents seeks to take further instructions in this regard. Paragraph, let the matter appear under the same heading on 19 July.
As lordship pleases.
Not your lordship, can you give me some time because I do have my some problem, domestic problem. Sometimes I may not be available because somebody of my not is in the hospital.
So
Lordship, can you keep it in the
27
August,
27
first weeks of August, first week of August.
27 July, end of July.
Kindly keep it in first week of August. I do have
Second,
my own
second
petition.
August.
I am not opposing that on personal
Second.
grounds. Second August. Gratefully, lordship.
Item five. For accommodating me for this longer time.
Next,
Item 5.
আজ আমার ফাইভ আমাদের তো দে আচ্ছা নাকি হ্যাঁ দে 5 নম্বরটা কোথায়
yes, petitioner,
I am for the,
service complete.
yes, yes,
Lord, I'm appearing for the
it is every service.
evening.
Pradhan,
Where is she?
Lord, may I some,
Panchayat Shomiti and
Yeah.
not Pradhan, against the actually block development officer. The action taken by the block development,
10 and 11 service was not
Yes.
done.
I've given the wait service. Actually, the action taken by the block development officer, representation is made to the block development officer, that has not been considered. Now the facts remains, may I submit?
Give me a minute.
কোন instruction আছে কি?
Instruction তো নেই
Consider the representation হবে.
Pradhan has not been served.
I have not allegation against the Pradhan.
Will you delete his name? Will you expunge his name?
No, I am the allegation only against the block development officer.
Will you expunge his name?
No, this is not the name.
11.
instruction নেই
Not required, let it be my lord.
Yes.
Not required for expunged. That my lord, the action taken by the,
If you do not expunge, you have to serve.
I serve.
Not serve. That
না,
is
জজ
the way
সাহেব
it's
বলছে যে তুমি যদি এক্সপান্স না করো তুমি সার্ভ করে আসতে হবে
Then also required to be expunged.
Yes,
Required to expunged.
I'll
If it is not,
expunge.
yes, my lord.
not
Or
necessary.
allegation against the my lord, block development office.
So not necessary. I'll
Not
expunge.
necessary. Only things, my lord, if it the hearing taken by the block development officer or the subdivision
What
officer,
is the matter about?
Lord, matter, my lord, relating to the realty property, Lord, the steps has been taken for setting up a water tank.
In your property.
Water tank. That is now without having no acquisition, no notice has been given, steps has been taken. Lord, for the very outset, I say, my lord, when I file the read application, the work is stopped now. That is my lord difficult.
What
So
is
far,
your prayer?
my lord, the prayer, my lord, the annex of P6, page 32. That should be considered.
By the BDO.
By the
Block
video.
Development Officer.
বিএলএল এর কাছেও দিয়েছে তো
ভিডিও করেছি, বিএলআরও করেছি, বিএলআরও করেছি, এই কারণে ল্যান্ডটা মেজারমেন্ট করতে হবে তো। কারণ ওর অ্যালিগেশন হচ্ছে যে
But if I am not mistaken, it has to go, your lordship, can you see, there was an order of as his lordship then was Justice N.K. Mitro.
আছে তো,
That is at page
আছে
21,
আছে আছে আছে
page 21.
হ্যাঁ, আমি সাবমিট করব
তুমি করোনি?
না, এখন শেষ করিনি, আমি কিছু বলিনি, আমি অ্যানেক্সার করেছি তো।
Page 21, there was an order of
This
charter.
relates to record of rights.
This is, my lord,
Correction of record of rights.
this is things for a moment, my lord, wrongly,
Perhaps it is relates to the land dispute,
yes, not
the
dispute,
specified act.
not dispute. My lord, the things for a moment, wrongly, my lord, the land has been recorded as vested. But the 44-2A proceeding, it has been held, that is not the vested land, retained land. But record has not been corrected. went to the Land Defense Tribunal. Thereafter, my lord, the case has been filed before this honorable court. Court directed to initiate the proceeding and correct the records. In spite of that, the order has not yet been passed. But still, I am in position in terms of the order passed the 44-2A proceedings, written land. My respectful submission, one things, my lord, record has not been corrected. There is another things, but I am still in position. I made the prayer stating all the things in my representation. That is all the things pending to me in the meantime, not to take steps for setting up the water tank. That was not considered. Let the authority consider the same, all the things. I am not suppressing things. All the things in records.
You are trying to encroach upon his land. He is filed a representation. This is not for correction of records or anything else.
Then your lordship kindly direct
Please be
the
considered.
consider in accordance with you.
And expunging the name of the.
That's, I have no objection to that.
On prayer of the petitioner. On prayer of the petitioner, the name of the Pradhan, comma, Ramnagar Gram Panchayat, comma, the 11th respondent be expunged from the cause title of the writ petition. Paragraph, the cause title be amended accordingly. Paragraph. Affidavit of service. None appears for the 10th respondent. Despite service. Paragraph. Is contended on behalf of the petitioner that the state respondents are taking steps for installation of a water tank in the land belonging to the petitioner without acquiring the same by due process of law. Stop. The petitioner submitted a representation in this regard before the concerned authority on 8th December 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that who should consider the video?
He has made the representation to BLL. Last time he said
To the
case 33.
Video and BLR.
32.
I'm Jani.
Case 32, he has made representation to BLL or case
BLLR will not consider video.
Page 32.
BLLR will demarcate if
Page
necessary.
32 then. তো সবাইকে দিয়ে রেখেছো।
Sixth respondent.
জানুক সবাই সাপ্রেশন করার কোনো
Sixth
প্রশ্ন নেই।
respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner, comma, in accordance with law.
During no coercive action, my lord. Since my lord, the direction is given.
No further construction in the petitioner's land till disposal of the representation. A paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the representation, comma, no further construction shall be made by the state respondents
Communicate করে দাও।
in the
করে দাও।
land of the petitioner.
Much appreciated.
এটাকে আপনি communicate করে দাও।
আরে দিব রে বাবু। প্রধান তো চেঞ্জ হয়ে যাচ্ছে, চিন্তা করছো না?
Disposed of.
Item 6. My lord, Ansar Mondal, he is for the state. He could not come to the due to his illness. His leg was broken. My lord,
State,
yes, my lord.
petitioner.
This for the petitioners. My lord, I am praying not this week.
My lord, I am praying for leave to file 2 supplementary affidavits after the order of your lordship dated 15th of September, which was challenged before lordship because of the non-communication of the order. Contempt matter was filed, contempt matter was disposed of by your lordship. And after that matter, they communicated the order. I have used that order, my lord, in my affidavit of the supplementary affidavit. Let me file those 2 supplementary affidavits.
2 supplementary affidavits.
2 supplementary affidavits.
That is on a completely new cause of action.
No.
Because the writ
No.
petition was filed for non-disposal of the,
Well,
because
that-
your lordship directed for reconsideration. Since the recorded reconsideration was not done, the writ petition was filed. Now it appears from Mr. Samanta's submission that the order has been passed, it has been
What
communicated
is
to
the
him.
time? What are you communicating? What you saying to the court?
If it is
If you
disposed
are-
of, whether writ petition is
I-
maintainable.
Brought the Supreme Court judgment, my lord.
Today,
The belated compliance is no compliance.
today in any case.
For
the
that
state is
contempt remedies, contempt is there.
My lord was kind enough to dispose of the matter.
Today, the state is asking for an adjournment. Come back with your supplementary
May I
evidence.
file,
I'll consider.
grant me leave, my lord, so that I can file and serve them.
You'll file it today itself?
Yes, yes.
Affidavit of service. On prayer,
তুমি একটা না-
supplementary affidavits
বাবু, তুমি একটা
Affidavit বলেছিলেন না?
filed by the petitioner are taken on record.
আচ্ছা,
Paragraph on prayer of
এই
the
তো,
same
এই
respondents, the matter is adjourned. Let the matter appear under the same heading
তুমি
on 9th August.
my lord.
আমাকে দিলেন হ্যাঁ, একটা
ওই
কপি
যে।
একদম
জুড়িয়ে গেছেন আমরা।
যে মুখ হচ্ছে সেই affidavit
ও আপনি আচ্ছা
submission করলেন আপনার।
7.
My application is minutes. Well, this impugn order has been passed by ADF District Magistrate Authority.
This is an appealable order in terms of. Rule
I
51.
admit,
Yes.
but the appellate authority should be a direction that the appeal must be disposed of within a certain period. Because of this, the several matter has been pending. So Lordship kindly
You have
pass an
crossed the
order.
limitation period, I'm sure.
Limitation period, Lordship, has been elapsed. That has to
So
be,
two directions cannot be given. I'll give only one direction, not to consider your limitation.
Lordship,
Disposed upon merits.
minutes, Lordship, but
Where is the order?
the page 172. Page 172. Lordship. Page 172 started from 172. The impugn order on 20th October
79.
2022.
179, ballot last page.
Concluding part.
Rejection 179.
In view of the facts and circumstances after news rules 2021.
Date of the order is 20th October.
20th October 2022.
So I'll relegate you to the appellate forum.
Lordship.
Affidavit of service. The order passed by the additional district magistrate and
20th October না December থেকে
and
order টা?
land records officer, Purbo Bardhaman.
Hmm.
On 20th October
আচ্ছা।
2022, turning down the prayer of the petitioner for extension of the period of lease is under challenge in the writ petition. Paragraph, the said order is amenable to appeal under Rule 51 of the West Bengal Minor Minerals Rules,
Concession rules.
Minor Minerals Concession Rules, 2016. Paragraph, in view of the above, the writ petition is dismissed for
Intervene করা।
comma, being not maintainable. Dismissed, comma, being not maintainable. Paragraph, however, the petitioner is at liberty to approach the appropriate forum for redressal of his grievance. Paragraph, in the event the petitioner files statutory appeal within 15 days, within 15 days from date, comma, the appellate authority is directed to deal with the appeal on merits without dismissing the same on the ground of limitation. There shall, however, be no order as to cause such and certified website.
Lordship, kindly direction that as early as possible the appeal be disposed of. Lordship.
Disposed of it আগে একটা line করুন. It is expected that the appellate authority shall dispose of the appeal as expeditiously as the business of the authority would permit, comma, in accordance with law.
Yes.
Item 8.
I appear for the petitioner in this matter, my lord.
Yes.
Lord, your lordship will kindly come to at page, Lord. Last page, your lordship's order. It is covered by your lordship's earlier decision. Lord, at page 33, annexure before your lordship, identical matter, I am praying for similar direction for consideration of my recommendation regarding grant of mining lease, long-term mining lease in the attending circumstances. Similar matter, I am praying for similar direction upon the authorities. The representation at page 31.
It's the same thing, higher,
Same,
higher
yes,
bid was.
hardware, similar cause of actions, identical matter. I'm praying for similar direction.
Your
Let them take
representation is at page.
at page 31. Annexure P3. Sand mining block of 25, INB 25.
Yes.
Sand mining block for MB, INB 25. Area is different only.
The mining block is different.
Yes, yes. Block is, area is different, nothing.
The area is different.
Area different. And other points are similar circumstances. Respondent number 2 may be directed.
Respondent 2 na 4.
Third learned counsels
Four
for
হবে।
parties.
Additional করে দেব না।
Dismissed করলো additional.
Additional করে। My lord, respondent number 4 will consider.
2 or 4 করে দিন, 2 or
না না 2 or 4 হয় না, কোনো এক। Contempt কার নামে হবে?
4 has to consider.
4, very well. But
The petitioner participated in an e-auction for grant of long-term mining lease floated by the respondent authorities. And was declared as the highest bidder therein. Despite depositing the requisite amount before the authority, you were not declared as the highest bidder by the authority,
yes, I was declared.
but the LOI was not issued in your favor.
However, subsequently it was cancelled, and in order to get the higher bid, no bid was available. It remained as it is. Then I made a prayer to get it as on a higher rate of 10% more.
Letter of intent was, letter of intent was not issued in favor of the petitioner. Stop. Subsequently, the authorities floated another e-auction for a higher bid, which was cancelled due to non-availability of bidders. Stop. It is submitted on behalf of the petitioner that the petitioner is agreeable to pay the higher bid money, which is 10% more than the earlier
Yes.
bid. Which is
10% higher, I'm ready to get it. 10% higher.
which is
higher.
10% more than the earlier bid, and is interested to get the sand mining block for mining operation. The petitioner submitted a representation in this regard before the concerned authority on 5th April 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on behalf of the respondents that the fourth respondent
Yes,
be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 6 weeks. Within 6 weeks from the date of communication of this order, upon affording
oppor-
reasonable opportunity
yes.
of hearing to all the stakeholders, including the petitioner, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of. To the affidavit of service.
my lord, the affidavit of service may be kept in the record. Item 9. I am for the petitioner. It's the identical matter, my lord. Bring for similar direction. Lord, your lordship's order is at page, Lord. Page 33, Lord.
So let the same order as in the earlier.
Yes,
requisition.
earlier one. Similar direction, maybe only the area is different.
Where is your representation?
Yes, representation page 31.
Only thing, my lord, the presentation, there is no, my lord, endorsement or no receipt, whether it has been submitted or not.
But in that event, the authority has the liberty to,
Not only that, there is a
reject it.
signature in my copy.
This is a copy.
This is a copy, type copy.
আমার কপি তেও নেই তুই
Yes,
দিয়েছো
type
কিনা তার তো কোনো এন্ডোর্সমেন্ট নেই কোনো রিসিপ্ট নেই সিল নেই কি করে বুঝবো
But unless a representation is made, the question of,
নো নো নো
my lord, it must have been submitted with the authorities.
let it be considered he make express application before the authority.
No, no, I will
There is no
produce,
endorsement, no receipt,
I will
nothing,
produce the
nothing,
copy.
there is no
During
signature.
hearing, I will produce the copy.
Whether it has been submitted or not.
I will produce the copy of the letter during hearing.
এখানে লাগাতে কি হয়েছিল?
Affidavit of service, undertaken upon same order, representation at date. 5th April 2022. Same.
নেই আমার কাছে থাকলে তো দিয়ে দিতাম।
যাইনি বাবা তুই রিপিটিশন ফাইল করার
In
জন্য
6 weeks, Mr. Bandhavani.
Yes.
I appear for the petition.
Yeah.
But may I place the affidavit of service? I have served, my lord, track report shows that item delivered. Well, grievances that, my lord, respondent number 9 is constructing
Who is appearing for the state?
state, my lord. I have served, my lord. I don't know, my lord, who is appearing, my lord.
And the private respondent.
Private
also?
respondent also, my lord, I have served. Respondent number 9.
Yesterday, may I request you, please serve a copy to me.
My lord. You serve.
Yes, what is the matter about?
Lord, respondent number 9 constructed a Paka lab, my lord, building on PWD land, Lord, just beside the road. Free space kept by the PWD. He has constructed property on the building on the said space. I made a representation to the PWD so that the enclosed land of PWD can be removed. My ingress and egress is disturbed by that particular construction. I made a representation. I want that representation to be considered by the respective authorities. Representation is at page 36, my lord. Assistant engineer, PWD.
Certificate of service.
Representation है, ऊपर है कुछ।
None appears for the private respondent despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and complains that the private respondent has raised unauthorized construction by encroaching upon a portion of the PWD road. It's the PWD road adjoining the petitioner's property, thereby obstructing his egress and ingress. Stop. The petitioner submitted a representation in this regard before the concerned authority on 22nd August 2022, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, it is submitted on শুরুতে কোনো none appears regular is called. Sorry. Service. None appears step. None appears for the respondents despite service code. For the private despite service.
Sixth respondent.
Sixth respondent be directed to consider the representation in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondent, in accordance with law.
Grateful one.
Disposed of which.
Item 11.
11, I'm appearing.
Madam, I am for the petitioner, madam. Petitioner applied for the short-term mining lease, madam.
That's what item number 12.
11, 12 and 13.
12, I am 12, my lord, I am not for the petitioner, my lord. 11 and 13, I am for the petitioner, my lord.
In all the matters, West Bengal Mineral Development has made a party respondent, but copy has not been served. This is a very peculiar practice adopted by these. I would say that these advocate on record in previous occasion also on 3 matters, your lordship ultimately directed the petitioner to serve me notice, and thereafter lordship disposed of this matter. There was no requirement for adding mineral development as a party. When we will not serve notice upon him.
He has to be made a party.
And they are
My
making
lord,
respondent
this
matter.
is
They are
very
My lord, my lord,
unfortunate practice.
my lord, I don't know, my lord. It is a change bid to me, my lord. It is a transfer bid. This is
Please serve and come back.
lordship. Lordship, then kindly make it not today, my lord. Only not today, my lord.
তুমি পার্টি করবে তো পার্টি
আরে আমি জানতাম না এটা আছে। এটা আমার কাছে ট্রান্সফার বি
দিয়ে দাও
এই তো বলো তো এত
পাঁচের মনোরঞ্জমান
ওই
না, না, তিনে।
জুনিয়র যে লম্বা করে।
হ্যাঁ তিনে
বললেই হয়তো যে এটা কপি দিয়ে
You are appearing for in 11
11 and 13.
and 12 is along with 11.
I am in the 11 and 13 for this
12,
state
Lord, I appear on behalf of the state respondent. 12.
12 petitioner.
No, my lord, 12 is no petitioner is.
It's the same advocate on record.
No, my lord, 11 and 13 petitioner came to me, lordship, but my lord, 11 and 13 came to me, my lord, by taking no objection from him. But that's the problem, but 12 has not come, my lord.
Similar matter, my lord,
Serve and
similar
come back,
matter.
let us see. Yes.
Similar matter. All the matters are similar.
11 12
Identical matters, my lord.
না কিন্তু এই যে শর্ট টার্ম বলেছে এখন শর্ট টার্ম
এই
প্রভিশনই নেই।
হ্যাঁ
Since copy of the writ petition
সেগুলো
along with annexure there
exceptional circumstances.
has not been served upon the third respondent. You are the third respondent,
Yes.
the petitioner is directed to serve the same upon the third respondent in course of this day. Paragraph, let the matters appear under the same heading on 3rd August.
My lord, kindly make it some privilege. My lord, 11 and 13, my lord, 12, I am not for the petitioner, my lord.
11 and 13 has also not been served.
I am serving only
Comment on that.
lordship, but my lord, 12, I am not concerned, my lord. 12, I am not concerned. Then my lord, again he has come and my lord say that 12 was 12, make it another, my lord, another order.
Yes,
বলে
the
দাও না একটু,
petitioner
বলে দাও
in
তো।
WPA.
কাকে?
12 এ কে আছে? মনিরুজ্জামান?
মনিরুজ্জামান নিয়ে আছে।
of 2023.
আরে ও অ্যাপিয়ার না করলে আমি কি বলবো?
13 এও same order.
হ্যাঁ 12 বলো ডিসমিস করে
Since
দিতে বলো তো 12।
আমি জানি, আমি কেন?
Since service not made.
সেপারেট অর্ডার ছিল, সেপারেট।
Yes.
হ্যাঁ 11, 13 same order and 12 my lord separate order.
11 and 12 are tagged, 13 is a separate matter.
Yes, then again my lord, let the tag be.
I am 11 and 13.
Order. The petitioner in WPA number, we have to line from 11.
My lord, your lordship is,
Copy not served.
my lord, your lordship is tagging 11 and 13 together.
I am not tagging, it is already tagged.
Oh,
11 and 12 are tagged.
11 12
13
ট্যাগ
is
আছে,
separate
তাহলে সেপারেট আছে।
But my lord, let it be separate, my lord. 11 and 12, let it be separate, my lord. Otherwise,
matter. One day you come and say tagged, second day you come and say separate cannot be considered.
Let it remain for the time being.
Yes, yes.
Let us come on the next day.
Identical matters, my lord, identical matters.
13.
Would be governed by a certain.
same.
I'm appealing for the state.
3rd August. Same order. Please serve and come back.
তুমি একটু সার্ভ
Next,
করে দাও।
14.
পেয়েছি, কোথায় বসাই দিলেন?
Your Lordship, I am led by Mr. Sudipta Dasgupta. I am for the petitioner, Your Lordship. He could not come today due to some personal inconvenience, Your Lordship. Kindly make it not today, Your Lordship.
On prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 9th August.
Lordship, I am appearing for respondent number 5 in this.
Give your name. 15.
কাগজ দিয়েছেন। 13 মিনিট করে দিচ্ছেন তো আমাদের সারা সুভাষী থেকে 11, 12, 13 লেখা আছে। I am for the state.
Petitioner,
এর কতটা?
petitioner, you are appearing. No one for the petitioner. None appears for the petitioner. Let the matter appear under the same heading in the monthly list of August 2023.
My lord, I am appearing on behalf of the respondent number 5 and 16, Bardhaman Development Authority, my lord. Hello, my lord, I am praying for not today, my lord, on behalf of Lanet Advocate Mr. HON'BLE. My lord,
I am for the National High Authority.
he has not.
Prayer of the petitioner, the matter is adjourned. Let the matter appear under the same heading on 9th August.
My lord, all other matters are pending in the combined monthly list, my lord. Your lordship kindly direct.
17.
That order has been under appeal, my lord. Appeal court passed the order.
Come back, come back.
What do you think?
Nine.
17, my lord, I am for the petitioner.
Yes.
My lord, in this matter is about, in the record of rights, my property,
Mr. You are appearing.
No, 9.
my lord, I have served the
17.
I've served
Service.
affidavit of service, my lord. I have served the learned government pleader, my lord.
Yes,
I have served the learned government pleader, my lord.
that is sufficient.
And
And what
my lord,
about the Panchayat?
Panchayat, my lord, let me just submit. My lord, in this is a matter where,
Submit, I would like to see the service.
sorry, my lord.
Yes, make your submission.
My lord, this is a matter where in the record of rights, my property has been wrongly recorded as Devottar property. I know my lord has no jurisdiction over this, so I will kindly visit your lordship to just grant me liberty to approach the proper forum of law
Very good.
and dispose it of, and my lord may dispose it of, my lord. And my lord, if my lord could make a small direction to dispose of this matter in front of the tribunal expeditiously. My lord.
The tribunal has its own size.
As per your lordship.
Affidavit of service. The petitioners, the petitioner seeks to withdraw the writ petition and approach the appropriate forum for redressal of his grievance.
So very good.
In view of the same, the writ petition being WK such and such is dismissed for non-prosecution. Paragraph, liberty is granted to the petitioner to approach the appropriate forum for redressal of his grievance.
Obliged, obliged,
There shall however be no others because urgent certified writ second.
obliged.
Dismissed. Non-proceed.
18. My lord, 18, I prefer not today, my lord. Kanajal Samant, he has not come today, my lord. Adjourn this matter, my lord.
On prayer of the petitioners, the matter is adjourned. Let the matter appear under the same heading on 10th August.
10th August. No. 19.
My lord, I am appealing for the my lord petitioner. I am filing this affidavit of service as well as my lord one supplementary affidavit. My lord, the petitioner, my lord, is running the my lord, running the brick field.
Running the
Brick field business, my lord. And he manufactured the brick, my lord, from the private land, and the land, the clay is lifted from the private land. And although the my lord, the respondent authority issued the to assess the royalty, my lord, at page 23, my lord.
yes.
And thereafter, the petitioner, although the petitioner made a representation at page 24 for exemption to pay the royalty. Due to my lord,
Yes.
now my lord, the petitioner challenges, my lord, the royalty may not be payable because since the petitioner lifted the clay from the private land, even there is no my lord, privacy contract between the respondents and the petitioners, either as a licensor or licensee or lessor or lessee. So I am covered by the my lord, several judgment of this honorable court as well as honorable Supreme Court, that unless there is no privacy between the land petitioner and the respondent authority, as well as if the shield is not lifted from the government land, so royalty is not payable. So my submission in no case prayer is my lord, the since the I have already stated in this several statement. So let the respondent number 2 distinguished maybe consider treat the writ petition as representation and consider it in accordance to law after. Now notice was issued by the BLLR. Royalty notice was issued. Distributed and collected. So let the petition be treated as representation and consider it after.
You file a fresh representation, annexing all the relevant documents as well as the judgments that you're referring to. File a fresh representation before the authority.
Fresh representation.
Stating the entire facts.
Yes.
A fresh comprehensive representation.
Yes, yes.
Yes.
Yes, ma'am. I am not.
There is district land and land development officer, we made a party of the first. He is the authority, not him the authority. In all the cases, my lord, district land.
Additional district magistrate and please.
District land.
Yes, ma'am. I shall make the representation before the appropriate.
He should be a party to the writ petition. I'll grant you liberty to add
Yes,
him as
ma'am.
a party. affidavit of service. On prayer of the petitioners, liberty is granted to implead the additional district magistrate and district land and land reforms officer, Purbo Medinipur,
Yes, ma'am.
Purbo Medinipur, as
Purbo.
respondent number 4 in the writ petition. The cost title of the writ petition be amended accordingly. Paragraph. The petitioners contend that they have been running a business in the name and style of Ashar ASHR, Ashar Pradeep Brickfield, in their own land and have no privity of contract with the respondents, despite which the respondents, by a notice issued on 3rd January 2023, demanded royalty and cess from the petitioners for production of bricks and extraction of earth. Paragraph. Learned counsel for the petitioner submits that in absence of privity of contract between the parties, the respondents are not entitled to claim royalty or cess in respect of extraction of earth and production of brick in the petitioner's private land. That is
Yes,
justice.
private.
The petitioners seek to submit a comprehensive representation in this regard before the concerned authority and pray for a direction upon the authority to do petitioner to consider the representation at the earliest. Paragraph. It is submitted on behalf of the respondents that the 4th respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the 4th disposed of with liberty to the petitioner to submit a comprehensive representation before the 4th respondent within 15 days.
Yes, ma'am.
Within 15 days from date. Stop. The 4th respondent is directed to consider and dispose of the representation within 6 weeks. Within 6 weeks from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioners within a week thereof. Disposed of.
And next is also my lord identical.
20.
Same.
Same. Yes. And here is the notice 18, notice page 18, and then also the next representation
Where is the notice?
at page 18, 1-8.
Same matter, notice at date 3rd January 2022. Same one. Add one. Next.
What is it? Now I am correct.
21.
Hello,
Hello, 21, Mr. Oil Manager is appearing for SBS TC. I'm praying for not today, my lord.
But only report is necessary because kindly see, my lord, without any acquisition, bus stand already constructed. Only 1 decimal was acquired. Civil suit was filed against the LA collector and the collector. Kindly see the finding of the judgment of the civil court.
Yes, my lord.
Not the state.
No.
State is submitted report. But page 24, Malad, kindly see.
Come back because it's not ready. State is also not represented. So come back.
But state Malad already sub.
Yes, but not represented. Come back. Affidavit of service. On prayer of the 5th and 6th respondents, the matter is adjourned. Let the matter appear under the same heading on 10th August.
Personal appearance আছে
Any affidavit of service.
It's on record.
22.
22, I beg to appear on behalf of the petitioner, my lord. This is my affidavit of services, my lord.
For the state, my lord.
The matter relates to, my lord, encroachment of national highway land, my lord. My lord, petitioner has purchased the land beside the national highway authority, national highway, my lord, by deed of sale. Now, my lord, after purchase, record of rights, my lord, prepared. What happened is the private respondent has encroached, my lord, the land just in front of the house of land of the petitioner, which has obstructed the ingress and egress of the petitioner, and that lands belong to, my lord, National Highway Authority. And my lord, after filing the writ petition, the authority concerned had taken steps. Kindly see, my lord.
Who is appearing for the respondents?
My lord, I have served. The track report shows, my lord, it was delivered.
You're appearing?
State, my lord, instruction from the bearer of the name of.
You are for the same.
ওটাই দিয়েছি.
Have you served the private respondent?
Engineer Kakim National Highway.
Same. This is the same letter, I think.
হ্যাঁ,
No, this was issued earlier, 31st January 2023.
my lord, let them complete the process, my lord, within a time frame.
Served.
My lord, served and it was delivered, my lord. It was delivered. I have submit the, my lord, track report. Twice I have served, my lord.
PWD land,
No, my lord. National Highway.
encroachment upon national highway.
National.
The PWD is in, it's under supervision of the PWD.
Supervision, my lord, by the National Highway Authority.
Where is your representation?
My lord, my representation is at page 4, running page
So
33,
pursuant
34.
to this, they have taken steps.
My lord. Pursuant to this writ petition, my lord. After filing this writ petition, they have taken steps. WPA number 839.
This will be under the West Bengal Highways Act.
My lord.
West Bengal Highways.
My
Act.
lord.
Affidavit of service. None appears for the private respondents despite service. Let this be concluded within a stipulated time.
My lord, my lord, my lord,
Yes.
my lord.
The petitioner complains unauthorized construction raised by the private respondents by encroaching upon a portion of the national highway, which is under control and supervision of the Public Works Department. This is Kagdip,
Kagdip, my lord.
Kagdip, South 24 Parganas, thereby obstructing his egress and ingress. National Highway open adjoining his property policy. Obstructed, adjoining his property. Thereby obstructing his egress and ingress. Paragraph, the petitioner submitted a representation in this regard before the concerned authority on. What is the date of your representation?
My lord, date of the representation is, my lord,
28th September.
26 September.
Where do you find the date?
My lord, 33, page 33.
26th September 2022. Which, comma, not being considered by the authority, comma, the petitioner came up before this court with the present writ petition. During pendency of the writ petition,
This one number 6.
it appears from the copies of letters filed by the petitioner as well as the state respondents that during pendency of the writ petition,
This one number 6.
a letter was issued by the Assistant Engineer Kagdip NH Subdivision to the Block Land and Land Reforms Officer Namkhana on 31st January 2023, requesting the latter LATTER to arrange for a joint field verification for necessary demarcation of the allegedly encroached land. The reply issued by the Block Land and Land Reforms Officer to the Assistant Engineer on 6th June 2023 indicates that joint verification was supposed to be held on, has this been done?
No, my lord, I don't have such
Yes.
instruction. No, that has not been done.
Held on 21st June 2023. Paragraph learned counsels for the parties are not able to apprise the court as to whether such inspection has been held. Paragraph, be that as it may, since demarcation of the allegedly encroached land has been is under process, comma, the concerned authority being the Block Land and Land Reforms Officer Namkhana is directed to cause joint field verification / demarcation of the same within 1 month from date and submit a report to that effect before the 1 month demarcation and submit a report to that effect before the Assistant Engineer Kagdip National Highway Subdivision within 1 month from before the Assistant Engineer, Kagdip National Highway Subdivision within 1 month from date. Report should come within 1 month.
My lord.
Upon receipt of such report, in the event encroachment upon government land or any portion thereof is detected, the Assistant Engineer Kagdip National Highway Subdivision,
Respondent number 6.
being the
Respondent number 6.
sixth respondent hearing, shall initiate proceeding under section 10 of the National Highways Act 1964 and take such proceeding to its logical conclusion within 2 months thereafter, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law.
I'm grateful.
Disposed of which?
For the petition dismissed.
Report.
Finally, my lord.
Have you received a copy?
Yes, yesterday evening, I have.
Completely in favor of my petition.
Yes.
Completely in favor of the petition. I have given the detail, I have seen it, completely supports his case. The only difference remained between him and me. He first said that employment will be given. I said, yes, I will give employment. Usually in many cases, we are fighting tooth and nail for employment. Here we offered him the employment. Then she said, no, I will not take employment. I will take the money, land value. Then as per the agreement, I said, I will give you this value as per the RR policy. Now he is asking that, no, I will not take employment. I will not take the land value. I will take the market value as per the name. So that probably is not possible. But other two parties, of course, possible. Now my learned friend will place the.
Do you want to use an exception to this?
Not necessary.
Not necessary.
No.
Okay.
If you lordships kindly see the very short affidavit they have, my lord, filed. Page 2, 6A, my lord, paragraph. They have admitted that there was a commitment of employment as well as land value and, my lord, other benefits as available under the RR policy.
Yes, yes. Thus I'm still saying.
Now, my lord, thereafter, page, my lord, 6A paragraph, page 2, internal page 2, my lord.
বুঝে গেলি? তোর কি চলবে?
আমি কিছু করবো না তুমি দেখো। Now, my lord, if your lordships kindly come. Paragraph, my lord, F of the same. My lord. Page 4, paragraph F.
Yes.
Now, my lord, admittedly, my lord, at this stage.
My learned friend is continuing. I will come back by 3 minutes, Lordship. Code number 2 is calling me. I will come back by 3 minutes.
Now, my lord, paragraph 8, if your lordships kindly come. Page 5.
Yes.
Now, my lord, at this stage, since, my lord, they have, my lord, already admitted that I am land loser under the policy. They were denying till late, my lord. Only I will pray before your lordships. Whatever the benefit, financial benefit available under the RR policy, let them provide. Nothing more. Whatever, I am not asking any quantification. I am not saying anything, my lord, that your lordships kindly indicate this. Whatever the benefit available under the RR policy, financial benefit available under the benefit, let they pay to the petitioners. Only this prayer I am, my lord, praying at this stage. My prayer, if your lordships kindly come. At page 17, 16. It starts from page 15. Market value, etc. I have read. But market value under the policy.
Memo number 979.
My lord, memo number 979. This is this memo, possibly, my lord. Page, my lord, 19, my lord. This is the decision of them by which land has been taken over. Since they were, my lord, denying the right, I have also, my lord, prayed quashing of this memo. But finally, since my lord, they are agreed, my lord, only I'm praying, my lord, very innocuous
They
prayer.
have also referred to this memo
Yes,
in the report.
yes. So I am praying only innocuous prayer, whatever the benefit available, financial benefit available under the RRA policy within a time frame, my lord, manner, my lord, let them, my lord, disperse that amount.
Yes, are you agreeing to this, madam?
My lord, Shiv Shankar Banerjee is coming within 3
তোমার
days.
এফিডেভিট অনুযায়ী তো বলছি বাবা, আর তো কিছু বলছি না আমি আপাতত। In paragraph 8 of the report, in this context, one can see, as per the competent approval obtained in this regard, either employment can be provided to Prubali Nandi as per the approved norms guideline of Coal India Limited, and as per prevailing RR policy of CIL, or in a case of without employment, negotiated land value along with one-time cash compensation can be provided as per norms. So negotiated and one time is not permissible.
Paragraph?
Paragraph 8, internal page 5. I have paid employment way back in 2016. We are in 2023. So at the distance time, my lord,
So as per prevailing norms of the RR policy of
yes,
CR,
I am only saying, my lord, whatever the financial benefit available under the RR policy, let they, my lord, release that amount within a, my lord, time frame, my lord. I'm not asking anything. Since it is admitted position by them, so why are we argue all the merit of the matter, my lord?
where is Zeno?
Lordship, according to paragraph number 8,
Yes,
according to paragraph number 8, look, without employment negotiation, land value along one-time cash compensation cannot be provided. Yes, Lordship, according to RNR policy, it can be done.
so it can be provided. You are agreeing to this?
My lord, I am agree, Mr. Shiv Shankar Banerjee is
It's
coming.
on record, it's already affidavit they have filed.
Yes,
Ask for 3 minutes, that is over. I cannot wait for him any further.
Lordship.
Report in the form of affidavit submitted on behalf of the ECL is taken on record. It's the ECL, is it?
ECL, ma'am.
Same.
The primary prayer of the petitioner was for cancellation of the memo number 979 dated 1st September 2014, issued by the chairman cum managing directorate, comma, Eastern Coalfields Limited, comma, Sanctoria,
My lord, Sanctoria.
SANCTORIA, Sanctoria, comma, post office Bishergod, DISHERGARH, comma, district Burdwan. The said notification demonstrates the modalities notification is an administrative approval for purchase of 30.35 acres of land with 15 numbers of employment under package deal. Modalities of such purchase and offer of employment are also recorded in the said note, in the said notification. The petitioners claim to be land losers who have parted with possession of their land in favor of the ECL authority.
My lord, original writ petitioner died. Now, before your lordship is substituted writ petitioners.
Yes. What are substituted writ petitioners. And submitted that the compensation granted to them was not in terms of the 2013 Act. That was your initial submission.
My lord.
Was not in terms of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013.
No, my lord, their policy is different, not that act, my lord. They have own, my lord, RR policy. I have
You say
annexed.
it was not in terms of the policy.
Not a policy, but your lordship quoted, my lord, the act. That act is not applicable here, my lord. They have.
Paragraph, page 8 of your writ petition. That was your submission.
Right. Writ petition. The Fair Compensation Act is not applicable. The act applicable here, my lord, the policy I have annexed, that is at page 50.
Say that you have not been adequately compensated.
Yes, that way, my lord, kindly mention that.
Huh? Was- না, ওখান থেকে বাকিটাকে দিন, was granted to them was not adequate.
In terms of this evidence, act করা। In terms of this evidence, act করে যায়। আমি লিখে দিয়েছি কোন টাকা পাবো।
না, না, ওইগুলো বলার দরকার নেই। ওগুলো বলতে গেলে তো ঝামেলা আছে। তাহলে তো আমাকে আবার ওগুলোর কন্ট্রাডিক্ট করতে হবে।
কেন কোনটা? এটাই তো দেবি তুই। এটাই তো ল্যান্ড ভ্যালু পাবি, এটা পাবি আর এটা পাবি। দেখো, এটা পাবি, এটা পাবি, এটা পাবি।
না, ওটা পাবো না।
চাকরি নেবে না বলে দিয়েছো তো। বলে
He
দিয়েছি।
is agreeing to paragraph 8 of your report.
Lordship, paragraph 8 of my report.
He says whatever your policy give,
RR
whatever
policy.
benefit is available to them in terms of the RR policy, he is accepting.
RR policy. So, Lordship, kindly also mention, because RR policy changes, RS policy of his relevant of that point of time, whichever was available.
Yes.
Now, my lord, they have switch over from that part, my lord.
What switch?
Kindly not mention anything as per their RR policy, let they provide.
That keeps a second round of litigation.
Otherwise, if I go on this.
Affidavit by affidavit, I am admitting his case that I will give him the benefit under RR policy, which was relevant at
You have said prevailing RR policy.
Prevailing RR policy.
That is the
that
present
prevailing
RR.
on that time, date.
That is not stated here. Please come to paragraph 8. Prevailing means as on this date.
Yes.
No, Lordship, this cannot be. Then the
It is your report, sir.
Lordship, then in this context, as per the competent authority obtained regarding employment, can provide employment as per the approval norms. In case of without employment, land value, one-time cash can be as per the norms and the prevailing policy of CIL.
Prevailing policy means policy as on date,
Yes.
not as on that.
Cannot. Lordship, this cannot be. Then this paragraph
So,
8 has to.
Paragraph 8.
No, why I said 8, then Lordship, paragraph 8 has to be seen in light of paragraph 6.
Kindly see paragraph 6. Why I said prelim. I given the entire detail in which board meeting I did.
All that is all right, but that has nothing to do with paragraph 8.
No, then I cannot look into.
Kindly see paragraph 7, my lord.
I understand.
Paragraph 7.
Not fallen from your lordship. Kindly take my submission once, lordship. Paragraph 6 quantifies the time and essence. Kindly see paragraph 6, lordship. I said how much I will pay.
Say prevailing policy.
Lordship, I kindly appreciate para 6 also is there. I cannot take one paragraph which is favoring the petition. I am not going in a advisory form. I am giving a very straight affidavit, lordship. It took me a lot of time to convince my client that there should be end to a litigation. Lordship, kindly see. In 233 meeting held on this, approved for this, the package deal and purchase of 30 acres. Lordship, then the meeting held this, the compensation value with employment and without employment benefit as follows. So I have detailed it. Land value, this per acre will be paid to this with the employment of this ratio.
6A2 also says.
Lordship, A2 is
On
this,
pro rata
who are
basis
all
to
not
be
eligible for the employment. This as per the pro rata basis of the class of land to be provided. Yes, lordship.
In that event, my lord, may I submit one thing? My landed friend has said, in case of without employment, negotiated land value along with one-time cash compensation can be provided as per norms. So in that event, kindly keep the matter pending. Kindly send my client before them so that negotiation can, my lord, be reflected before lordship. Otherwise, lordship, my lord, kindly.
Let's do one thing, lordship. What my learned friend said, in view of the affidavit given by them, he will be appearing before my client. My client will adjudicate the entities. It's government company. No one will take his money, lordship. Kindly have this much of faith. Otherwise, this affidavit would have not come.
The rates are in question now, nothing else.
So that they will decide if they whatever the policy they have, they will.
6 also you say to be provided as per RR policy of CIS.
Yes. Lordship, in any case, forget I said something or I do not say something. In all case, lordship, whenever it's a employment, compensation, money, whatever it may be, it has to be calculated on that day.
Not necessarily if the authority decides otherwise, where it is.
That's what I'm saying. So lordship, do not fasten the authority with a particular direction. Lordship say that we will dispose of this as a.
No, that gives rise to another round of litigation. Keep on this. Paragraph.
Otherwise, lordship can keep it as applicable to them.
Paragraph 6, small a. Paragraph শব্দটা লিখুন আর প্যারাগ্রাফ করে লিখুন প্যারাগ্রাফ মানে paragraph 6 small a within bracket II of the report in the form of affidavit submitted by the ECL demonstrates that those who are not eligible for employment, an amount of rupees 6,06,000,000 per acre on pro rata basis.
My lord, I am disputing, my lord, this quantification. That's why I am not going to this. Only simply say, my lord, kindly as per the RR policy. Otherwise, if your lordship mention this, I'll be deprived. Otherwise, I will go for employment. 5 lakhs and 6, my lord, 6 lakhs is not nothing.
Your employment is open.
Nothing, because they have delayed the employment.
Submission, so please wait.
Otherwise, kindly, my lord, give me one chance so that I can, my lord, file, my lord, an exception. Otherwise, my lord, if your lordship, my lord, this part, 5 lakhs and 6 lakhs, because they have delayed. I have applied 2014, they have taken over the land. Now they are saying they will give the employment. Will they, my lord, provide the employment with retrospective effect? They will not.
Lordship,
they have delayed. That's why, my lord, due to their dilatory tactics, my lord, I am compelled to accept this. So simply say, as per the RR policy, let they provide, my lord, to whatever the financial benefit. Otherwise, I will go for, my lord, the quantification, because if your lordship kindly see, the RR policy says that the market rate and etc. amount has to be given.
She got married, she settled at Delhi, she could not come for employment. It is only, this is the case of Pubali Nondi. Pubali Nondi refused employment. Now I cannot fasten with the liability of compensation. Pubali Nondi, kindly come to page 11.
Pubali Nondi is not before this court.
That was his prayer.
Referring to Pubali Nondi.
Lordship, kindly come to page 11.
Pubali Nondi is not either. Pubali Nondi is not
There is such person.
Kindly come to page 11, Lordship. Kindly come to
But
page
they have,
11 of my report.
they have followed, annex the document which is not the party to these proceedings.
No, Lordship, kindly see. To the General Manager, Sirpur area, prayer for employment under land user scheme.
Who is this person?
Lordship, let me read this. In light of the land of the Ashok Nondi, Pubali Nondi was the nominated daughter. She is the daughter of the man. Uncle, Lordship. Then the uncle referred the matter to the next of his kin.
This is the employment scheme.
Lordship, then I said that I will go for the employment because I was getting a young person. I will not give money. I will get work and money. Then they shifted from employment to compensation. Then I said, it's all right. I will consider your compensation. Now, Lordship, kindly turn to the next page. That was page 12. I processed his everything, Lordship, signature of the nominee.
Well, page 58, if your lordship kindly come.
Lordship, kindly see page 12. and
What
page
is,
13.
why they are scared, my lord? If your lordship is direct that as per the RR policy,
Neither I
let
am
them
scared
decide.
nor bold. I am only saying it's a government money, has to go in a proper form. Lordship, kindly see 13. Then he
Page 58, if your lordship kindly come.
all along run the case of employment.
I cannot help you. Yes.
Lordship, then he all along ran the case of employment. That's what I'm trying to show. Even if we have taken a lenient view today.
Because
Because
one person has died, who will take the employment? Read petition has died, my lord.
Checking, sir. Let him complete.
Lordship, Ashok Kumar Nondi at that point of time forwarded Pubali Nondi to be the candidate for job. That is page 12 and 13. Now, Lordship, kindly come to page 14. What was my agreement when I was taking the matter?
That is recorded in paragraph 6.
Lordship.
That same
So
thing.
page 14 is the recording. Now, Lordship, if your Lordship kindly see, today they are saying, I will take compensation only because that Ashok Kumar Nondi died intestate. Someone has left the job.
Let
So
me
now
complete
the
my
other relatives are taking money and they want to squeeze money out of me. That should not be allowed, Lordship. Compensation is in lieu of someone's employment I have destroyed.
I'll record both paragraph 6 and 8. 8 was in your favor. Then let them take a decision. I'm bold. Lakhs per acre on pro rata basis, irrespective of classes of land, to be provided to the landowners. Reported page 3 te page aa raha hai. As land value without employment benefit and with monetary compensation in lieu of employment at the rate of rupees 5 lakhs per acre on pro rata basis to be provided as per R&R policy of CIL. CIL capital. Paragraph 8 of the report
Read with 7, my lord. Kindly also see 7, my lord.
states seven is their discretion. States that as per competent approval obtained in this regard, either employment can be provided to Purbali Nondi within bracket likhun, recommended for employment by the original writ petitioner, bracket closed, as per approved norms / guidelines of Coal India Limited and as per prevailing R&R policy of CIL, or in case of without employment, negotiated land value along with one-time cash compensation can be provided as per norms and prevailing R&R policy of CIL. Paragraph, it is submitted on behalf of the petitioners that the petitioners are agreeable to accept the benefits they are entitled to under the prevailing norms, under the norms of the prevailing R&R policy of the CIL. That is your submission.
Only one thing, my lord, if your lordship kindly come, my lord, to paragraph H and I of page 5. Kindly see, my lord.
How
On
does
such,
it matter now?
kindly see, my lord, on such and such,
applied for GM for claiming market value of land as per ADSR rate for determining stamp duty and other charges at the time of registration on the so my lord, because I have made the details claim in my representation. Page 60,
Instead of doing
60,
that, what I'm saying
65,
is I'm
66
comparable.
and 68.
Where is your representation?
Page 60, 65.
They can make a fresh representation that will be composite. Then my learned friend can draft it. It will be a more composite.
He says this is composite. isn't it?
Well, no, he is asking that fresh representation. Okay, very well, I will make fresh representation.
কিছু কথা তো শোন বড়।
Change কথা বল।
ও ফেভারে বললেও চাই মানে ও ধরে নিয়েছে শিবুদার এগেইনস্টই বল।
কেটে দিন ওইটা কেটে দিন। In view of the above দিয়ে শুরু করেছিলাম এটা। কেটে দিন পুরোটা। The petitioners seek to submit a comprehensive representation before the concerned authority stating the entire facts as well as their claim along with relevant documents and pray for a direction upon the authority to consider the representation at the earliest. Paragraph, in view of the above, the writ petition is disposed of with liberty to the petitioners to submit a comprehensive representation before the fourth respondent within 7 days,
No, well,
15 days,
within 1 month, kindly, because I have
1 month from date. Stop. The fourth respondent shall consider and dispose of the representation within 1 month thereof, 2 months, within 2 months from the date of receipt thereof, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof.
and they will consider as per RR policy, kindly mention, my lord.
I have stated that earlier.
My lord.
Body of the order.
ওটা বলেছিল আর পলিসি অনুযায়ী কনসিডার করবে। শুনতে পাচ্ছি না।
সবই তালুক তো তোমার
তালুক
সব গভর্নমেন্ট নিয়ে নিচ্ছে
Yes.
IAPF for the KMD.
It is disposed of. Not called as yet. Give me a minute.
24.
Oh,
This was the system of justice, late Justice S.B. Sinha. Before it is reached to the, finally reached to the Justice Sinha, matter is disposed of sometime. So this humble prayer I cannot exceed because of the fact, my lord, my client will be suffering immensely. If
What
adjournment
is
is
this prayer actually?
adjournment. Right.
Yes.
But under 1952 Defense of India Act, the central government acquire property through state government for their own purpose on the Defense of India Act. The land was available with the central government. Central government leased out the property in my favor, in favor of the petition. Vast chunk of land for different purpose, for the purpose of act. Thereafter, my lord, as I was holding the property as a lessee, all these Kona Expressway, my lord, acquisition proceeding initiated. Some land was taken, some is, my lord, compensated, some non-compensated. I am not, this is not the list before my lord. So, my lord, I was not allowed to utilize my property. There is no demarcation. Which property you have taken, which property still I am lessee. A writ petition was moved before your lordship's court. Your lordship's court was pleased to direct the authority to demarcate it. It was not done. I filed a contempt application. When the contempt application was filed, a report has been filed validly. Court said that some compliance is there. They have filed a report. Contempt disposed of. Thereafter, my lord, it has not been properly demarcated, so I filed this writ petition again. That proper demarcation is necessary. Matter was continuing. In the meantime, private respondent, my lord, I find the private respondent is encroaching my property, who is according I am the lessee. On inquiry, came to learn the KMDA transferred the land in favor of the private respondent. I say that till such time this is not demarcated, still where I am the lessee, because I am the lessee, lessor is the government of India. You cannot do this. My lord, in the now the one application I have filed. This is post writ petition, so I file an independent application that is being heard by my lord. If your lordship kindly, one document I want to show to your lordship, kindly come to the earlier report filed in compliance of the order passed by your lordship's court. 61. If your lordship kindly come to page 60 starts, kindly come to 61. The writ petition.
Yes.
Others, my lord is hearing this application now. Others, I am not traveling today. But kindly come to
Where is the application?
application. Kindly take up the writ petition. Kindly take up the writ petition.
I have to challenge the maintainability of the.
There is an application, he says.
This is my application. Kindly take the writ petition.
No,
What I am showing
is for hearing of the application only. Or
I
the writ
don't know.
petition
My lord,
itself?
application I have filed. That your lordship can take up along with this application
What is
also.
the application for?
Application, my lord, that the third party, my learned friend's client, should not interfere with this land of mine.
On the last occasion, we have questioned the maintainability of this.
Mr. Basu has not there. I'll tell you what. My lord would find the two persons have been alleged. Added respondents, my lord would find this is scan 3 of 2023. Page 3, the cost title, my lord, one is JIS Group of Educational.
Yes.
Another is added respondent number, and another is, my lord, I do not know the abbreviated version. Possibly it would be Chief Executive Officer. JIS Group. I said they are not legal entities. My lord said, let them add them, let us be added. Whatever the objection is, you take it at the time of hearing of this application. Because till you are added, you cannot raise any objection.
Who you are appearing for today?
My lord,
Whom you are appearing for today?
my learned, I have learned from my senior not to interrupt. My question is, there is two persons have been added. GIS Group of Educational Institute, there cannot be any group. These are not legal entities. My learned senior knows it better than me. There is no legal entity. GIS Group, Tata Group is not a legal entity. There are separate companies. We in a normal court we say that this is now you say CEO of GIS Group of Educational. CEO, I handicapped today. Chief Executive Officer is defined under the Companies Act 2012. which says it has to be in connection with one company. But today, kindly, my lord, appreciate a person has come and he's making us allegation that my land is being encroached. My Malayalam senior friend started with the fact that the previous round of litigation, that writ petition is still pending. To the best of knowledge, because we were not parties, whatever I have read, but from the pleadings, it appears, my lord, this is pending. My lord wanted to see the orders on the previous occasion, wanted to see what has happened to that writ petition. That is pending. Now, my lord, suddenly it comes up and says these two persons are encroaching on us. But first one subject to correction, my lord. Whatever legal, my lord, I know Order 7 Rule 1, when applicable, when a person has to file a claim, you have to describe, the description has to be proper. Subject to correction. But defendant, but there are also judgments. Order 7 Rule 11 will apply if there is no proper description of the claim. But if he is failed to describe, then what the consequences? But these are not legal entities. But he has no, there is no allegation against a person of encroachment, and you do not name that person. But can a writ go into the written inquiry? Second, my lord, I had pointed out this particular company which they have referred to was incorporated in the year 1930. In the pleadings, it is shown, my lord, it was incorporated in 1956. And third, my lord, the writ petition, the relief paid for in the related petition, does not have any connection with this particular relief. Which my learned senior friend has also shown, everyone had shown there was not. That's why my lord wanted to see the previous writ petition. But my lord, first,
I find there is another application for addition of parties. Who has
which
signed
was
this?
disposed of, my lord said.
That is your application.
No, their application, my lord, we have never been, my lord,
Can the electric manufacturing company?
yes, well, they are the petitioner. writ petition.
Can one was for adding them as part?
No, what happened, my lord, without adding, what happened, my lord, initially without adding, they had paid reliefs against. So I think my lord was of the opinion that without adding the respondents privately, you cannot pray for anything. They withdraw an application and thereafter they had filed. And my lord, also if my lord,
Can
Mr. Basu was not there, but everyone will agree, my lord, whatever the points you have to raise, you cannot raise this points. Till you are added.
What is, how can you, why don't you help us out with the proper nomenclature?
That's why I ask you, who is appearing for today? But there is a doctrine, this is called doctrine of representation.
Petition is not maintainable.
Who are you first?
Kindly, writ
Petition
petition.
becomes not maintainable when an opportunity of amendment is not availed of,
No,
not
but
prior to that.
I beseech my lord, kindly see the prayers in the writ petition and kindly see the prayers in the application.
You say that you cannot represent the added
But
respondent.
I say,
So who
they are
should
no,
do added?
that I have to seek instruction because.
Who is appearing for today? Let him file the Bhagavat today, my lord. Now I am serious.
No, my lord, kindly.
He cannot be have any audience today.
Who
If
has
he is not
signed-
there.
Who has signed your Vakalatnama?
But I have to check, but I have to check from Lord.
Who is that Bhagavat is appearing?
I am afraid before that, I don't think you can have a right of audience. You say that you cannot appear for these two entities.
I can accept there may be difficulty. You are nobody here. Don't make any submission.
For whom are you appearing, sir?
But I have to check the Vakalatnama, I guess, which one I.
You are appearing without checking your Bhagavat. And I have taught you this. He started with that I have learned him, taught him.
Just.
You can resolve it. That this is the actual nomenclature of the party.
But then I have to seek instruction. Can you give me? Because difficulty is, my lord, on the previous occasion, my lord specifically had the prayers, my lord, with deepest respect, my lord, the prayers of your interim application does not match with the petition. You have to come back with kindly see his interim relief and what are the plot of lands he has asked for and what is the relief prayed for in the.
Prior to that, you should tell us who you are representing, sir. Then we will have.
This type of subject raises suspicion that he is in wrong footing. He is doing the mischief.
Yes, my lord.
But his client. His client.
Given to us, but that is the submission.
Yes.
But everything,
I am not going into merits at all today. please clarify your stand. Since you say that these are not the,
But these are not legal entities. Then who are you? Same question.
who has granted you the Vakala?
But I have to check that.
You are representing someone.
Yes, sir. Without checking what happening? What, Mr. Chakraborty? You are not a toddler today. আপনার কাছে তো toddler। No, not at all. আপনার কাছে তো toddler।
My lord, I
সবসময় বুকে বুকে হয়ে যাবে নাকি? সবসময় বুকে-
I also raised that point of maintainability of this can, particularly this can, whether this can be maintained in connection with the writ petition. If your lordship sees that in the writ petition, the petition, in the writ petition prayer is something else in respect of
Yes.
some land. But in can, altogether a different, in respect of altogether a different land.
Technically, my learned friend is correct.
So can application must be made, my lord, in the aid of the.
He is absolutely
So
correct.
what-
I scolded my
What
junior.
contention has been
You should have
made.
filed an application for amendment.
Afresh. Yes.
But in the writ proceedings, my lord, there were goes so much technicalities. Had it been a suit, yes, without amendment, you cannot say anything.
No, but it is not.
I know that. I know that. That's why I say I am not raising my voice to that. But I am submitting, my lord. Today, I come with a case that without demarcation, my property has been utilized by some of the orders. Kindly demarcate it and settle it out. Without doing that, the KMD is transferring the property to somebody else. But kindly, that's why you want to show to your lordship one page, page
So will
61.
you not press the application?
File
Today,
a fresh.
today, my lord, problem is that I bow down to your lordship. I say it is not in proper form. But if your lordship once kindly come to page 61, then after I will
61.
seek of the writ petition.
Yes,
But kindly come to bottom, column 7.
yes.
And at C8, C2 is the now where Mr. Chakraborty's client is now making construction in aid of this KMDA. Total land 0.85. 0.65 acquired, no doubt. But so far as this 0.20, it said it was under Act 6162 case 1. This was never acquired. If this is clarified before my lord, I will withdraw my petition.
That cannot be considered on this application. This application, my lord, should not enter.
Courts is the handmaid of justice. Technicalities.
For entertaining, my learned friend either has to amend the writ petition or to file a fresh.
In the meantime, third party right will be created. I will be in problem. This is our fault. I am not blaming anybody. It should have been on a basis of amendment application. But fact remains, this is the only list before my lord in the application.
File your application in the meantime because he has to come back with instructions.
I don't know who is appearing for. Let him disclose. Again, this same point. I am appearing, but I don't know for who I am appearing.
No, fresh service will not be necessary because he is already appearing.
To whom to serve? Again, this point.
Not
I don't
necessary
know.
at all because learned counsel is there. He has to say for whom he is appearing.
Landlord counsel will not do. The proper party has to be made out.
Let
He
him
don't
file
know
that.
from whom he is appearing.
In the meantime, why don't you come back with an amendment application?
Well, I will, but I am afraid of this third party right. They are going to enforce that property. Mr. Chakraborty's client. If that is protected for a week, well, this is the problem. This is the problem. If my KMD has shown to your lordship, this is the acquisition. I dismiss my application on that ground. And this is a case of demarcation only, nothing
This
else.
can application was filed, affirmed in February 2023.
আমি তো ছিলাম না বাবা।
So within a week, anything may happen. That apprehension cannot be
Come
there.
back with further instructions.
This is my situation, my lord. Thereafter, your lordship kindly
20th,
decided any
20th,
in the manner, my lord, your lordship.
yes. 20th July, Mr. Bas.
Yes, yes. I will ask my learned friend to amend it in the manner amendment application and can he dispose of this application will liberty to move afresh. This can
Not necessary.
not necessary. I will file another
On the
application.
next day, file a fresh application and this can be withdrawn.
It can be withdrawn by my lord.
No, no,
Or
ঠিক আছে,
not pressed, whatever.
this will be an amendment application. Order 6 this is not on that form.
If such an amendment application is made and this application must be withdrawn,
It's a তখন হবে।
It will be done simultaneously. No?
Well, if possible, my lord, any observation to protect my client. The situation is such that at least whatever is they are doing subject to result of this application.
Any
At least
steps
this-
taken in the meantime
at
shall
least
be
this
shall
much-
abide by the result.
And no equity will be claimed for that.
Heard learned counsels for the parties.
And my lord, before lordship starts dictating, let him serve us to whom I have to make party.
I have to take it.
Learned counsel for the,
My instruction is, there is an infrastructure hospital government, there's a joint effort of the government, there's a hospital is being. Well, there is a bar.
you are on merits again.
No, I'm not, I'm telling you why, there is a bar under the amended specific fact that there cannot be in injunction in respect of any colleges, college.
I'm not granting an injunction. I'll only say that any action taken shall abide by the result of the writ petition.
Yes,
It's not an injunction. It's at your own risk and peril. At your own risk and peril, you'll do it.
With some respect, whether today an order is, order, I'll inform whoever is the concerned person, but an order is being passed without whether there will be, if can you consider that I'm a third party, I'm a beneficiary of some, whether an order could be passed, any order touching my right, with deepest respect, while it is not a party to the person. If I'm not,
My lord is not hearing him. My lord is deaf.
if I'm not there,
He, who is he?
Someone we do not know, and you consider submissions on merits.
But I'm not on merits.
But any matter, I will come and make my submission. Any matter, I will come and make my submission.
I'm just a one sentence thereafter passes, just one sentence. But kindly consider that I'm no one. I'm only saying.
After all the submissions that you made.
Because kindly consider this, if today any order is passed, affecting any third party rights, where the petitioner chooses not to have implemented, where petitioner chooses not to implement.
Whether go and pray for an appeal. Even nobody here. He might not pass such an order.
For one sentence, one sentence. But whatever, I may not say a single word after sentence. But only thing I was.
Can you come back with your instructions tomorrow? I'll just make it not.
Friday, I fixed matter at the phone number. Friday, I have to. Friday, I have to. Friday, I have to. I just come. The fixed matter, or else I will come. I would have.
Very well, not this week, Monday. I'll just make it not this week without any order. Come back on Monday. Let us deal with the matter.
I will try to, my lord, file within that period.
Instead of Monday, my lord may keep it on Tuesday.
Come back, let us see. if you come.
ঠিক আছে হলে তখন দেখা যাবে।
Let us see.
বললে টাইম করবে।
Not this
আমার পেছনে।
Not this week.
মানে his name should not be recorded. He should not earn fees.
Recorded, no order passed.
He should not earn fees. চল।
কেন এরকম করছো বলো তো?
Next. Not this week. NTW code.
24. 25.
Lord, item number 25, for the petitioner led by Mr. Dheeraj Trivedi, and I'm praying for not today, my lord. He is on his legs before court room 34, my lord. Kindly, I'm for the petitioner.
Let me make it not to its time. Let us not prejudice the petition.
I'm great.
Not today.
Not today.
Item 84. 84 contempt application.
Well, I'm appearing for the order has already been complied with. Rudy করিস না আমার সাথে, দাঁড়া।
My lord, may I take your lordship to page number,
You are the applicant petitioner.
my lord. My lord, may I take your lordship to page number 20, an extra P2 of the contempt application. My lord, in the nutshell, there was a specific direction of your lordship setting aside a communication issued by transport department by which HON'BLE Motor and AN Enterprise e-rickshaw registration has been allowed by way of taking undertaking. My lord, thereafter, there were two folded directions of your lordships. One is that a letter has been set aside, and second was your lordship has been pleased to direct the special secretary respondent number 4 of the writ petition to issue a fresh letter strictly on the basis of the terms set out by your lordship. My lord, that was the specific order, my lord. My lord, thereafter, my lord, may I take your lordship to my contempt notice dated 24, my lord, page number 24. 25 is the relevant portion, my lord. My lord, with regard to, my lord, issuance of a fresh letter strictly on the terms set out by the honorable court, that has not been complied, my lord. My lord, a letter has been issued. Sir, একটু kindly hand over করে দেবেন।
That has been complied with lordship kindly see.
হ্যাঁ, স্যার আমি একটু সাবমিশন করে দিই তারপরে
Paragraph 3 and
একটু
4
আমি সাবমিশন
of the petition lordship kindly see.
My lord, this letter, if your lordship kindly
You can challenge.
go through the, my lord, peruse the letter, content of the letter, my lord, the terms which were strictly set out by the honorable court has been omitted. My lord, if your lordship side by side compare what are the terms and what has been mentioned in the letter, my lord, your lordship.
He has not annexed in the petition.
My lord,
Although it has been
just now I have
complied.
received from my learned friend. How can I annex? This is their so-called compliance, my lord.
2000
Just now I have
March
received
23rd,
from my learned friend.
2023. Order has been complied with.
My lord,
If he is agree,
If you say that this is compliance, this is not.
What?
Please come to the order under contempt.
lordship kindly see, my lord.
The
Page,
order is
page,
very specific.
page 10. Page 10 lordship kindly
Of?
see. Page 10 of the contempt petition.
Page 21, 22 is the order under contempt.
sir, এটা
Yes.
স্যার এখানে টার্ম সেট আউট ছিল দুটো রিট পিটিশনের টার্মসে, অনলি আপনারা একটা করেছেন, একটা ওমিট করে দিয়েছেন পুরো। দেখুন দুটো রিট পিটিশন ছিল স্যার, একটা 21440, একটা ছিল
এখানে
স্যার
কটা? একটাই রয়েছে।
এইখানে শুধু একটার মেনশন করে দিয়ে দিয়েছে।
এই
মানে
দুটো-
যেটা দুটো নাম্বার লিখলে হবে না, টার্মস গুলো তো সেট আউট করতে কোর্টের ডাইরেকশন ছিল।
The terms are different,
টার্মস ওয়্যার ডিফারেন্ট।
so it has not been complied.
So lordship kindly give me time, some time, my lord. I
Please
can-
come back after compliance. Let him take some time for compliance.
My lord, with regard to, my lord, under may I one more point, my lord, page number 27.
One more point.
Yes.
My lord, page number 27, registration has been granted by way of undertaking to the applicants whose letter has been set aside, my lord. On the similar terms, registration has been granted.
That is March 23, order has been passed.
My lord, the order has been passed on 31st of January, and this registration has been granted 31st of March.
On
My
the
lord, this is also on the basis of this letter. If this is contemptuous, then this will also.
It is equally contemptuous.
Then my lord, I shall take full instruction that will be.
You have to come back with an affidavit of compliance. It is submitted by the applicant petitioner that the letter issued by the Director, Transport Directorate on 1st March 2023 is in violation of the order under contempt. Paragraph learned counsel for the alleged contemner seeks accommodation to comply with the order under contempt and file affidavit of compliance on the adjourned date. Paragraph, let the matter appear under the same heading on 4th August should be sufficient. Paragraph, affidavit of compliance be submitted on the adjourned date.
যে কপিটা দেয় এক্ষুনি দিচ্ছি ছবি তুলে দিচ্ছি ধরো একটু খারাপ করে দিচ্ছি
4th August.
85.
That was similar. No, similar no.
Oh, 85, 86 was the similar.
87.
Only at time, sir. At time content.
87.
My lord, may I take your lordship to page number 158, my lord, of my contempt application?
Have you served?
My lord, I have served.
Where is your affidavit?
My lord, affidavit of service, my lord, is not ready. I have served, my lord.
So I do not find the contenders. That's what.
My,
Come back after service. Since affidavit of service is not ready, let the matter send it. Let the matter stand over till 4th August.
4th August.
Read.
88.
For the petitioner, lordship. Is the content application, my lord, copy has been served. This
I am for the respondent, your lordship.
affidavit of service. Well, page 14 is your lordship order.
It is a Pankajna Raghuveer.
Raghuveer.
Raghuveer first, Raghuveer.
Yes, have you complied?
Your lordship, there, an appeal has been preferred from the order. It's MAT number 1198 of 2023, your lordship. We had mentioned the matter as well for early hearing, your lordship. It's still not been
No
heard.
copy has been yet served. No interim order, no injunction, no stay.
Your lordship,
No, even no copy has been served till now.
I'll file an affidavit, your lordship, giving the same on, bringing the same on record, your lordship.
Affidavit of service. It is submitted, paragraph, it is submitted on behalf of the alleged contemner that the order under contempt has been carried in appeal before an honorable division bench of this court. Learned counsel seeks to use an affidavit in this regard. Paragraph, let the matter appear under the same heading on 16th August.
Your lordship, contempt's hard copy may be served or soft copy because it has been served on the department in Bihar. So by the time it comes to us, a copy will be served.
Follow up. Service. Next.
89.
Similar.
Same one.
Same.
Same order, carried in appeal.
Your lordship, MAT number 1199.
Exchange your lordship.
Next.
My application.
Well, I'm for the response. Yes.
This is my application, my lord. We are on pleadings completed, my lord.
You are for the respondents?
My lord, Railways is the principal respondent. My learned senior friend is appearing, my lord.
Who are the other respondents?
My lord, the Railways, my lord.
It's only the railways.
Railways,
Right.
different designations of the Railways. My lord, before I trouble your lordship with the papers, I'll just quickly indicate, my lord, in brief what the facts of the case are. My lord, I am a consignor. I transport goods. The particular transaction, which is the subject matter of this instant writ application, my lord, pertains to goods being maize. I buy from my supplier and I use the railways to transport the goods to different places. In this case, my lord, I transport the goods to Bangladesh, which is an overseas transaction. So naturally, there would have to be a customs clearance, etc. I put the goods in the railways sometime in November, my lord, of 2007, my lord. I'm sorry, my lord, 2006. I put the goods. According to the rules and the act, my lord, which I'll indicate to your lordship eventually, there would have to be a weighing of the goods that takes place. And pursuant to the weighing, my lord, there is a railway receipt with respect to the exact weight that is given to me. So in this case, that also happens. I put the goods in the railways, railway weighs it, gives me a railway receipt. Then after 5 days, my lord, they transport it and conclude the delivery to the consignee. So the delivery is complete to the consignee. Almost 6 months later, your lordship, the railway raises a demand on me saying that the weighing that I had given to the railways of the total quantum of goods that was the subject matter of transport was overloaded. So I had underweight the goods. There were significant portions of the goods that were not weighed. So with respect to that extra quantum of goods, they raise a demand upon me. Pursuant to the demand, my lord, I make a response to that. There is a subsequent transaction, my lord, with respect to delivery of further goods. There are 3 further wagons. They keep the goods as lien, saying that I will sell off these goods if you do not pay me the money. Now, good, bad, indifferent, my lord, as on date, because of an interim order passed by this honorable court, those goods have been returned to me. There was an order for a bank guarantee, etc. I'm not taking your lordship through that. I'm only sticking to the crux of the matter. I'll take your lordship through the papers now. Lordship, the original transaction, which is my contention, involved 1,942.500 metric tons of maize.
Affidavits have been exchanged.
Affidavits have been exchanged, my lord.
So they should be hearing matter.
This is hearing, my lord. This was appearing under the heading hearing till now, my lord. Your lordship has kept this under the heading motions for the first time today.
There was no directions for affidavits.
No, affidavits have been completed.
I don't know.
Affidavit, they filed their affidavit in opposition.
Okay, change brief. ठीक है. Only
Their
thing-
contention is very simple. I'm on law. I'm not taking the court through the facts at all. The facts are admitted. We've also filed our affidavit in reply. On September 20th, 2022, we filed our report.
Fine, yes.
Opposition, my lord, my instruction is that was filed in 2007 itself. Sure. Affirmation is declared over.
The opposition is also not in the file, I find. Just check.
But it's affirmed on the 3rd of August 2007. An order আছে recording the filing. Online check করার পর এটা online check করো, online check করো। Old 2020 এর আগের old করে দেখা
দেখুন তো opposition টা আছে কিনা। Reply is there, opposition I do not find. I'll just check. It's a very old file.
No, it's 2007 application, my lord, I understand.
And also, my lord, your lordship kindly go through the first order passed by Justice Debashish Kaur-Gupta. There is a specific directions for bank guarantee. Then only they can leave the materials. That bank guarantee was,
Furnished.
yes, furnished. So, my lord, that in the meantime, they have revoked the bank guarantee behind my back.
No, we've not revoked.
But
It's
regarding
expired by
my,
flux of
just regarding 11 lakhs which we demanded from them, that has not been paid. That is the only issue here.
They have asked for withdrawal of that demand. So why do,
But in the meantime, there was no, that cannot be, because my lord, I'm saying that admittedly there was an excess load.
No,
That
that
we
has
have-
never been the admission.
That is there. Admittedly, yes, because my lord, we have given them notice. that
Absolutely untrue.
It is, they have inspected that.
Acha, no. The opposition is not in the file, so please come back with your opposition.
My lord, only
The
difficulty is,
reply is there.
well, only difficulty is it transferred bill of 2007. So we have to, I don't know how to reconstruct this.
But it was transferred in September. I have a copy of the opposition.
Why don't you help?
I can hand up the copy right now. I wouldn't be requiring this at all. But it's a marked copy, my lord. If your lordship pleases, I can make a photocopy of this and come back.
If
It's
you
a
can
mark.
hand it over to, because he'll also need a copy, isn't it?
I shall make over a copy to my learned friend in that case.
Yes.
So please come.
If
back
they,
with a
but
copy of
I'll
the-
have to also be candid, my lord. With respect to the opposition, my lord, the only contentions they have are bare. I know they'll also have require the opportunity to look at it, but there is nothing apart from bare denials. I'm not even on facts today. I'll only argue on one judgment passed by the division of this division bench of this court, my lord, which states that in the case of a railway receipt that has been issued, that would be taken as prima facie evidence. So the moment they wait at the first juncture, they can't turn back the clock and say that they had weighed it incorrectly.
That judgment of Justice Sanjeev Banerjee, that has been sent to special bench.
There is a judgment passed by His Lordship Justice Bhaskar Bhattacharya sitting in the division bench. That is the law of the land at the moment.
That has been,
The judgment.
I'm carrying the judgment, my lord.
but the special bench
I'm carrying the
judgment হয়েছে? There are judgments, my lord. One is of Justice Sanjeev Banerjee.
Copy, otherwise.
Maybe I'll serve a copy to my learned friend. That I understand the difficulty. It's also from 2007.
The original is also lying in the brief of learned counsel, so please find out.
That is not there.
Record.
That is not there. Even then, my lord, let them serve it.
Very well, very well.
I'll
The
deal with that.
affidavit in opposition is not on record. Paragraph, learned counsel.
Lordship will
the
kindly keep it
respondent-
next week in that case, my lord.
No, August, next week not possible.
So August will be.
Learned counsel for the respondents seeks to submit a copy of the affidavit in opposition on the urgent date.
10th to
Paragraph, let
16th.
the matter appear under the same heading on 1st August. Under the heading hearing, group 7 hearing.
My lord, instead of first, can it be on 5th?
5th is a Saturday.
Oh, sorry.
No, my
Seven,
admin
seven,
record is in
seven.
a difficulty between 10th to 16th, my lord.
So seventh,
Seventh, I don't have any difference. Seventh.
7th August.
Hearing is. I'm deeply obliged.
দেখো খুঁজে পাও কিনা বলো আমাকে লিখে দিবি
I'm sorry, this is a group 7 here. It should be on a Tuesday. So it should be 8th August, not 7th. Group 7 hearing matters are taken up on Tuesdays.
We'll come back.
Amla, 8th. Next.
Deeply obliged.
91. 91.
Yes.
Come.
Yeah, I'm appealing for the petitioner. This, my lord, to cut short the matter, my lord, I respectfully submit before your lordship, my lord, that this instant writ petitions was filed, my lord, against the order of suspensions of allocations of priority C rec, my lord. And, my lord, again, on the ground, my lord, that a criminal case was pending before a competent court of criminal law. My lord, against that order of suspensions and deemed blacklisting, my lord, this instant writ petitions was filed, my lord. And upon moving of this writ petitions, his lord, my lord, Justice Nijamuddin Ahmed, my lord, as his lordship, my lord, was pleased to pass an order directing the respondent to pass an order after giving an opportunity of hearing, my lord, on the representations filed by the writ petition. My lord, pursuant to that, my lord, the order was passed by the railways, my lord. That, my lord, I have annexed, my lord, in the supplementary affidavit, my lord, I have filed before your lordship, my lord, at page 29 of the supplementary affidavit.
This was also pursuant to the order of.
Page 29 of the supplementary.
Page 20.
29.
Yes.
Last 4 line, my lord. In the meeting, you have quoted Honorable Court's order of 2014 regarding jurisdictions of railways to blacklist from availing railway service to a customer. In this regard, it is informed that railways have not blacklisted your firm from availing iron ore rakes by rail. Only preferential treatment in the form of priority C has not been given until a decision is communicated on the subject matter by Honorable Special CBI Court. Like any other customer, your company can continue to transport by rail under priority D, my lord. So therefore, my lord, now, my lord, that the requirement of allocations of priority C.
I do not find.
Yes, my lord. Page 30, my lord. Page 29, my lord. Last 4 lines, my lord.
Of the supplementary.
Of the supplementary affidavit.
Yes.
Yes, my lord. In the meeting. In the meeting, you have quoted Honorable Court's order of 2014 regarding jurisdictions of railway to blacklist from availing railway service to a customer. In this regard, it is informed that railways have not blacklisted you from availing iron ore rakes by rail. Only preferential treatment in the form of priority C has not been given until a decision is communicated on the subject matter by Honorable Special CBI Court. Like any other customer, your company can continue to transport by rail under priority D, my lord. My lord, now, my lord, since, my lord, that the petitioners has not been blacklisted, my lord, because it was revealed from the order, my lord, and the requirement of having, my lord, priority C allocations has come to an end, my lord, because the company's productions has already come to is very very limited, my lord. So therefore, this requirement has come to an end. So in that view of the matter, my lord, so we don't want to proceed with this matter, my lord. Only, my lord, it should be recorded in the order, my lord, that the petitioners has not been blacklisted as it was found by the railways in their order. So this is my respectful submission.
Yes. The petitioners primarily prayed for withdrawal of the impugned order dated 28th June 2019, passed by the railway authorities. Stop. Wait. 28th June. Paragraph. Learned counsel for the petitioner draws the attention of this court to a letter issued by the director within bracket rail movement bracket closed, comma, railway board / Kolkata to the director, comma, Messrs M/S Haldia Steels Private Limited within bracket unit Roman 2 on 7th November 2019, which demonstrates that the petitioners have not been blacklisted by the railways only preferential treatment in the form of priority -C has been denied to the petitioners, who are allowed to continue to transport by rail under priority D inverted comma. Paragraph. Learned counsel submits that since the petitioner's SL firm has not been blacklisted and the petitioners shall continue to transport under priority D, comma, the petitioners do not intend to proceed with the writ petition any further. Paragraph. In view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. Paragraph. There shall, however, be no order as to cost as a certified.
What presently may be added, presently is not required, because in future if it is required, then this order may put any embargo, so just not keep it open.
Presently not required. CETA is present not required. And full sentence since শুনতে পাচ্ছি না কিছু আপনার comma, more so, connect line accord, more so, since transportation under priority C is not required by the petitioners at present. In view of the same. Yes.
That was
this is not relevant.
If it's not, if it is required, then we'll make before the zonal date, right? It's not necessary.
A fresh application.
Yes. I'm grateful.
Next.
Discuss. 92.
Your Lordship, I am for the petition. Is the matter BSc conflict?
Lordship, kindly take it up on Monday. Because my eye is today morning. Eye is infected. I do not know. That is why, if my lord accommodate on Monday, that is kindly take it on
Monday week.
Monday week. That your Lordship.
24th.
My. Hey, Sathik.
Prayer of the respondents.
Please don't mind.
Several adjournments, Mr. Debra.
No, I know, I know, it is my business, personal physical account, my lord.
Please be ready. 25th. The matter is adjourned on prayer of the petitioner. Respondents, the matter is adjourned. Let the matter appear under the same hearing on 25th July.
No, কোনো অসুবিধা নেই, next দিন
93.
93 also same one. Mr. Naik is there,
Same matter.
same, I know, identical.
Order, same order.
Ninety-four.
Yes.
আমি আছি ও
94, I'm for the private respondent, Khushbu Singh,
94, I'm for the petitioner.
and 95, I am for the petitioner. Now, my lord, on the last occasion, I have indicated your lordship.
My lord had directed me, my lord, on the last
That-
occasion to come back with instructions regarding, my lord, the interest.
Let me complete the sentence. When my learned friend is aware of the situation, now, my lord, the amount has been kept with them. Tender, they have cancelled. Now,
You've asked for interest on them.
now I am leaving the interest. I am not pressing for the interest. Let them pay my amount as early as possible, preferably within 2 weeks.
2 weeks হবে না দাদা, 5 সপ্তাহে দিয়ে দিচ্ছি।
5 সপ্তাহ অনেক বেশি হয়ে যাচ্ছে।
5 সপ্তাহে
না, না।
15ই অগস্টের আগে হয়ে যাবে।
Let it be 3 weeks.
But we'll try to do it as expeditiously as possible.
No, my lord, your lordship can make it time, because I am not claiming for interest now. Something should be given to me also.
My lord, as early as possible, my lord,
3 weeks.
3 weeks.
kindly make it 4 weeks.
Right.
Kindly make it 4 weeks, my lord.
No,
So that, my lord, they,
3 weeks will be sufficient.
so that they need not come back, my lord.
No.
Your lordship, my lord.
My client will wait for 4 weeks. Before 4 weeks, he
My
will
lord
not
keeps
come
it
for
four-
contempt.
my lord keeps it 4 weeks.
That
I'm sure by then, আমি দেখে নেবো দাদা, ওটা যাতে চলে আসে।
We are not claiming for interest at all. We are only asking for our
Would have created
principal.
one more confusion. I mean, claiming for interest. আবার এফিডেভিট করতে হতো, এ করতে হতো, সে আবার এ হতো। আপনার পয়সা আপনারা পেতেন না।
ঠিক আছে।
Learned counsel for the petitioner.
4 weeks কবে শেষ হচ্ছে? আজকে কত তারিখ? আজ তো 12।
890 of 2022 submits that he seeks refund of the earnest money deposited by him in view of termination/withdrawal of the tender in question by the railway authorities and is not claiming interest thereon. Paragraph, in view of the above, the railway authorities are directed to
When the refund amount would be
fund
1
the
crore 30
earnest
lakhs.
money
Whatever the
deposited by the petitioner to the tune of
1 crore 30 lakhs, page 40. Your lordship, can you see page 40 in the second read petition? এই যে ওরা দিয়েছিল 50 লাখ, আমরা দিয়েছিলাম 1 লাখ। হ্যাঁ, আমিও দেখিনি। তুই যদি বলিস না দেখিস নি, তাহলে তো আমি আরোই দেখিনি।
where is the figure in page?
Well, at the top, not over 1 crore 30 lakhs. In the rupees column also, page 40, my lord.
নাম্বারটা বলে দিন স্যার।
Well, this is the read petition number 23890.
It's in Hindi.
No.
No. It is in English. 23890. Second read petition.
90, yes. Oh,
Well,
this is
kindly
the
takes page 40 and page 41.
This is the application that I'm.
না চাইলে দেবো না।
হ্যাঁ।
না চাইলে রেখে দেবো, কি আছে?
1 crore 30.
1 crore 30.
1 crore 30 lakhs. 1,30,000,000,000.
So 1 crore 30 to them and 50 lakhs to the private respondent.
Petitioner in ওটা করুন, তাহলে নাহলে গন্ডগোল হবে। Petitioner in WPA number 23890 of 2022 to the tune of A and earnest money of rupees 50,000.
50 lakhs.
50 lakhs.
Sorry, 50 lakhs to the petitioner in the first.
No, this is a private respondent.
The private respondent.
In both the respondent. In both the writ petition.
Lord, respondent number
ওতে দরকার নেই, এটাতেই থাক না।
Sendos Commercial Private Limited.
Sendos. He has been made application for addition of party, and that was allowed.
Not 7.
No. Application for addition of party was allowed.
5.
Oh, five.
The same petition.
Added respondent.
To in WPA same number to be.
No, not 5.
Yes, 23890 is 5.
Oh, yes, it's 5.
Added respondent.
5, yes. I'm sorry.
The most important part, within 4 weeks from the day, from this date.
But 4 weeks, it will come to 12th August. There will be a spate of holidays. So your lordship, because 13th is a Sunday, 14th.
আরে তার আগেও দিয়ে দিতে পারি তো, আমি তো চেষ্টা করবো দাদা যাতে কালকে আপনি পেয়ে যান টাকা।
ঠিক আছে।
Within 10th August.
Yes.
Within 4 weeks to get it in, within 10th August 2023.
Fine.
Unique calendar.
Both the writ petitions can be dismissed.
Yes.
And the interim orders may stand vacated.
Yes, the interim order stands vacated.
Kindly record. The interim orders, if any, stand vacated.
They have already cancelled the tender.
So we are waiting for the leave from the honorable court.
What is the?
We are waiting for the leave to act.
Interim orders were there in both the petitions.
Interim order.
No, only two, second matter, yes.
When we pass a common order, my lord, directing disposal of both the writ applications and my lord vacating
Both the
interim orders, if any, my lord.
Upon such instructions and observations, both the writ petitions being WPA such and such due to number given are disposed of. Paragraph interim order passed in WPA 23890 of 2022 on 10th January 2022 stands vacated.
Fine.
Since no affidavit, so it's acted.
Great.
No address to cause since no evidence, this effect.
A good riddance. Grateful to your lordship.
Next.
$96.
My lord, I am for the petitioner, my lord.
Yes.
As the contract is terminated, my lord, I would like to withdraw the application petition, my lord, with the liberty to file fresh cause of action.
So no liberty is needed. Liberty is necessary only when it's the same cause of action. This is a fresh cause of action. So no liberty is necessary.
My lord, kindly record my submission with,
Contract was challenged
my lord,
and that has been withdrawn,
yes,
terminated.
my lord.
This matter, my lord, in pending, we have said, my lord, in the writ petition that we have been given, other party has been given a benefit, my lord, when we are running a contract. They sought for a time, my lord, to come back before your lordship, and in the meantime, they terminated the contract. So, my lord, now we have to challenge, my lord, the termination of the contract. Therefore, my lord, this writ petition will not survive till, my lord, that our termination is, my lord, set aside by your lordship.
Mr. Ghosh was appearing. Where is he?
Not there.
Since you withdrew, no difficulty. None appears for the respondents. The petitioner seeks to withdraw the writ petition. Since the contract was subject matter of the writ petition. The contract was subject matter of this.
Yes, contract was part of subject. We said that we have entered into a contract, my lord, and we have been given 5 minutes, 10 minutes time, whereas, my lord, the other contract on the same train was given, my lord, the stoppage in a 5 minutes.
So which contract is cancelled?
My lord, my contract has been cancelled, on the basis of which I was claiming, my lord, I should be given a equal treatment along with, my lord, the.
Since the contract agreement on the basis of which the petitioner is claiming relief in the present writ petition has been terminated by the Railway Authority. Such termination has given rise to a fresh cause of action according to the petitioner, according to the petitioner. Paragraph in view of the above, the writ petition being WPS such and such is dismissed for non-prosecution. There shall, however, be no arrest cause, urgent certified website copy. Liberty is not necessary because it's a fresh cause of action.
Fine. Wait.
Next.
Not possible.
97.
And this is my application. Well, this matter was taken up time to time by your lordship.
Here's the report.
No copy has been served.
No.
We do not know anything about it.
Yes.
But this is relating to report, tax.
Transport Secretary, he had took a hearing,
Then, my lord, your lordship, can you take this matter on Monday so that I may go through this?
You want to use the exception?
Let me go through it first, then I shall, if necessary, I shall take. And if it is done, it will be done within Monday. It's no problem. And I shall send him the advance copy.
Instead of Monday, 20th.
28th.
19th.
No, Monday is 17th, 19th, yes.
Report in the form of affidavit submitted on behalf of the respondents is taken on record.
What was it?
Paragraph copy of the report is made over to learned counsel for the petitioner in court this day. Paragraph on prayer of the petitioner, the matter is adjourned. Let the matter appear on the same heading on 19th July.
July.
একটু আগে good heavens 12
98.
My lord, I am for the respondents. My lord, my junior SUVRA is out of Calcutta for some family reason. That's why, my lord, I am praying that lordship will kindly take the matter on 18th or 19th as your lordship pleases.
There is a persisting interim order, my lord, till 31st of July.
There is interim order till 31st.
Because
Come back on 28th.
28th, the lordship has fixed many matters on 28th. Lordship, any day prior to that, my lord.
26th.
26th.
26. I'm grateful.
On prayer of the respondents, the matter is adjourned. Let the matter appear under the same heading on 26th July.
I'm grateful.
60. Wait. 99. Lordship, I am appearing on behalf of the petitioner.
I am for the Yes.
Lordship, on the previous occasion, I already told that Lordship, the cost title is default.
Yes. Please take the microphone, madam. Continue, please.
Lordship, your Lordship passed an order on 20 June 2023. There is a cost changing in the cost title. Or I already told in the previous dates, Lordship, for the correction of the cost.
Correction of cost.
Yes, Lordship. Lordship, Kishore Jadhar versus the State of West Bengal insists of Kishore Jadhar versus Union of India and another.
Disposed of.
Yes, Lordship. Lordship, my another.
Oh, cost title of the order, last order.
Yes, Lordship. Lordship, my another submission is, your Lordship given directions to the respondent authorities complies with the order within 3 weeks.
Can
From
that be done in a correction application? You are also aware?
yes, Lordship.
Can that be
No.
done? We are only asking for correction of the cost title, isn't it?
Along with Lordship, extend the time period, Lordship, compliance of the with order.
My lord, kindly come to my lord, page 3 of your lordship's order, my lord. My lord, there is a direction, my lord.
There is a typographical mistake, nothing else, because Mr. Chakraborty was there all throughout.
My lord,
He's aware of the order, so there is no question of extension of time.
no. The postal authority,
Needs to be changed, that's all. No extension required, please.
no,
comply.
as per your lordship's direction, I taken instruction.
Please.
You only told me that they have to get some more time to comply your lordship's order, because some which officer will execute the agreement. So he is out of station. So they paid before lordship that they want to get some 2 weeks more time to comply your lordship's order, my lord. That is only.
This matter came up as to be mentioned. The matter has come up only for correction, so no other order will be passed in this matter.
Lordship. Till now, again,
Inadvertent error
time
has
will
been
expire on
order passed on
25
20th June 2023.
Ah.
Paragraph in the cost center of the said order. The state of West Bengal and others. Substituted by the Union of India and others. Paragraph, the department is directed to incorporate necessary correction in the order accordingly. Paragraph, this order will be treated as part of the order passed on 20th June 2023.
Grateful.
Next.
Order.
Where? Hundred.
In this matter, you.
The correction of dispose of matter.
I'm with the bank. Bank বিক্রি করে দিয়েছে। কি purpose has to be
Sir. But so far, my lord, this matter is concerned, your lordship was pleased to direct on the last occasion to my lord, to find out and the person who purchased the vehicle and to add him as a party responsible.
Mr. Debra wanted to come back with the report.
Yeah. And he was directed to come up with the report that whether the section 51 subsection 5 has already
Was
complied
not
with.
complied. Transfer of ownership.
My.
Not ready.
রিপোর্ট নেই
Let him come.
কোথায় চলে গেল
চলে গেলি না করলে পঞ্চায়েত ইলেকশনে everybody busy with পঞ্চায়েত
Panchayat election.
today
I don't know when
that is finished.
elections
Today is over.
results has come out.
next
also,
from
my lord,
next week everyone will be available.
How we now? On to the time we need sure.
The council for the state respondents seeks extension of time to submit the report in the form of affidavit as called for. Paragraph, let the matter appear under the same heading on 7th August.
7th August.
Affidavit was signed. ওটা ওখানে রেখে দিয়ে তো মামলা করতে যাচ্ছি।
Next. Correction matter. কিন্তু heading. Chande bola kan corrections. Next.
101.
My lordship, I'm for the petitioner.
I am for the state led by Mr. Naik.
Uh,
Yes.
My lordship, the petitioner is carrying a transport business in route number 26. That is from Chapadanga to Kolkata with valid permit. My lordship, the petitioner came to know.
There are several petitioners.
Yes, my lord, 7 petitioners. Came to know that State Transport Authority, that is respondent number 2, has introduced a new bus service from Gazamo to Karunamoyi which covers the major part of route number 26, my lord. My lordship, unfortunately, due to introduction of this new bus route by respondent number 2, the petitioner's right to livelihood is and survival will be hampered. My lordship, this is my submission to direct the respondent number 2 to consider a letter dated 21/12/2022, that is annexure P2.
At page,
Page 20.
Page 20.
the petitioners were not heard. They were not given
Pardon,
an
my lord?
opportunity of hearing.
No, my lord. Lord, kindly consider the representation. Led by Mr. Naik. কি হলো? না না ওই শুরু করেছে সবাই। এই কি representationটা consider ওদিন হয়নি গিয়ে
Let this be considered within
by
1 month
secretary ST.
by the secretary. Yes, let your complaint be considered.
My lord.
Grateful, lords.
The petitioners contend that they are operators in route number 26
My lord, the secretary STA.
from Chapadanga to Kolkata station on the basis of valid permits in their favor by the Regional Transport Authority, HON'BLE. Stop. The petitioners learned that the State Transport Authority, West Bengal, is introducing bus service from Gajar Mode, Gazar, Mode to Korunamoyi, which covers major part of route number 26, traversed by the petitioners. Stop. According to the petitioners, introduction of the new route shall prejudicially affect the business of the petitioners. Stop. The petitioners submitted a complaint in this regard before the concerned authority on 21st December 2022, which is yet to be considered. Stop. The petitioners pray for a direction upon the authority to consider the complaint submitted by them at the earliest. Paragraph is submitted on behalf of the respondents that the fourth respondent, secretary, the fourth respondent be directed to consider the complaint in accordance with law. Paragraph, in view of the above, the petition is disposed of, directing the fourth respondent to consider and dispose of the complaint filed by the petitioners dated such and such within 1 month.
Lordship.
1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all the stakeholders, including the petitioners, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners within a week thereof.
And
Which was the
within
1 month and 1 week.
kindly make it 6 weeks, Lordship.
6 weeks couldn't 1 week. Within 6 weeks or 1 week. Next. Two. Yes. Service upon sixth respondent complete. Bakura bus owners, anyone representing?
Well, I appear for the state, Lordship.
But Bakura Vasan, they received also one of them.
Delivered, yes.
17th of
This is required, yes.
the fact is that Malaki, so this is regard to fact, since law.
Could you please switch on the microphone? It's switched off.
This in respect of dispute with regard to timetable. My lord, the petitioners all along not operating the vehicles, my lord, since long. The lordship will find one after another order passed, even my lord. My lord, the dispute to be resolved so that the timetable can be given as a class 3 timetable to the petitioner so that he can operate. My lord, since long, my lord, he is once after another granted the timetable for a period of 1 month, and then an objections came, and that the objections, those came by the existing operators of the bus associations, not in the single name, by the owners of the, in the name of bus association. Name of the authority asked them also, and it took a decisions, and that not actually against in favor of the petitioner, not even they are also not satisfied to that. Now, the lords kindly come to the order. A series of order. I will not travel only thing, your lordship kindly come to the page 51 once.
51.
Page 51.
Yes.
Now, the order which your lordship passed on 26th of September 2022.
26 September, yes.
There your lordship will find the last but one last there your lordship kindly found that upon consideration with the page 2, internal page 2, page 52. But the last paragraph, upon consideration of the submissions made on behalf of the parties, the writ petition is disposed of, directing the fourth respondent to consider and dispose of the application filed by the petitioner dated 17th August 2022 within 3 weeks from the date of communications of this order, after affording reasonable opportunity of hearing to the all interested parties, including the petitioner and the private respondent, and also upon taking into consideration the letters issued by the Secretary Regional Transport Authority Bankura to the Secretary Regional Transport Authority Hooghly on 7th of March 2022 and 7th of June 2022 respectively, in accordance with law. Now, the decision taken by the authority shall be communicated to the petitioners within a week thereafter. Now, it is also made clear that the court has not, that is your lordship. Now, after that, your lordship will find that the page, the hearing took, this is notice on 11th of, that is the next page, 11th of October. The notice of the Regional Transport Authority.
Page?
Page, my lord, 53.
3 is not the, it's the order.
On the page, after your lordship's, my lord's order, that is page 22, the internal page 2 of the order.
Yes.
That is at in my revision page 52.
Page 53 is the concluding part.
Yes, page 53 is the last page of the order. Now page, then sorry, this is my mistake, page 54. Page 54 is the notice
Of hearing.
of hearing. And this the hearing held on 19th of October, your lordship will find that the next line, in compliance of the order, the next line to be held on 19th of October 2022 at so and so. And my lord, this has been issued to the petitioner as well as the copy forward to information so and so, so and so, and my lord, the at the top, these are the papers. Now, my lord,
Page 55 says you sought further time.
yes, yes. Well, no conclusions arrived at. Then, well, again, a hearing took place. That was 6th of December. That is at page 59. In terms of the proceedings of that is page 59 a memo. In view of the above, your lordship will find the notice. Page 59. Then again ask for 21st of December 2022.
Yes.
Then 21st of December 2022. My lordship, kindly come to page 61. My lord, no, my lord, the petitioners, my lord, could not, it was not possible for him to stay for long time. This is going on, this is going on. He make a representation and file a writ petition that your lordship's order of December 21, 2022. This is next writ petition. Page 2 of internal page 2 of page the writ petition page 62. Where it starts from second paragraph, first paragraph, it starts from since according to. Now we'll then you also come to page 63. Well, kindly note that this is very important. The notice says in compliance, you will also kindly see the notice. In compliance of the Honorable High Court order dated 21st December, that is the order earlier page. Now, order dated so and so, in respect of WPA number, this so and so, you are advised to send a comprehensive report on time of departure of the vehicle from Tarokeshwar towards Bankura. Now, you'll also kindly to whom this has been issued. From whom this comprehensive report was asked for. But your lordship kindly see Secretary Hooghly Inter-Regional, and the second one, the Secretary Bankura Bus Owners Welfare Association. Now your lordship kindly appreciate one thing, consider these things. These Bus Owners Association all along, as because they did not come into a amicable settlement of my timetable, your lordship direction, forget about all them. Let you take a decision. Even then, that on the basis of that order, they are again asking the association to give a comprehensive report to associations. Your lordship is aware of the much, but the fact that these associations having got no right in respect of the vehicle of, this is in their name. It's not an individual capacity. They are raising the objections. And the authority sitting an administrative body and a quasi-judicial body asking the comprehensive report from the association about the departure time from that point. Now, my lord, petitioner filed against that, your lordship, that was not taken up. Even your lordship kindly see the dates. Data January 5, 2023, the notice date. Now, they were asked to submit the report by 9th of January. Positively, it's there. Now, finding no other alternative, petitioner filed, petitioner going to file a contempt applications before my lord's court. Now, my lord, contempt, yes. Then, my lord, the notice when issued for contempt, the very, your lordship kindly see the date of 6 January is notice for contempt. That is at page 64. Yes. Then your lordship kindly come to page 65, that on 16th of January 2023. They of their own, they come to a conclusion that because of this. And the order referred to here of this similar decision.
This order is after the second writ petition.
After the second writ petition. And the page 2, internal page 2, page 66 of my writ petition, your lordship will find that the second paragraph, whereas before commencement of hearing, the petitioner is so and so further filed a writ petition one of that petition where your lordship is directed. And the Honorable High Court in its order dated, but this is, they were aware of the order that the Secretary is directed to take a decision. And the Hooghly to take a decision on fixation of timetable against the vehicle number. So this is now they therefore considering the above facts and circumstances and in compliance of the order, this is the timetable they have issued in respect of my vehicle. And there, my lord, I made an objection so far as the there are two trips, up trips and down trips. I have no objection so far as the up trip is concerned. Now you'll also kindly see these down trip. There is a gap of time, and the gap of time is difference about 50 minutes with the up trip. This is a difference of 50 minutes while in down trip. I don't know in between these 50 minutes where has to be taken. One is this, the other is that this down trip, that objection I have given, that has to be considered because I have given the specific, but that is at page 67. So far as this timetable is concerned, I made the objection.
67.
Page 67, and when you also will find that page 68. The reasons I have given in para A, B, marking as B, A, B. Your lordship will find that page 68, second para, then class, your lordship, the last line, why it is not class 3. Then, my lord, I have given the reasons for which this is not a class 3. The reasons are that some and some points directly, my lord, hits the timetable of another operator, specifies the number of the vehicle, and my lord, the timings given.
Consideration of this.
My lord, this. And my lord, so long it has not been considered, my lord, I have to allow my lord, because your lordship kindly see. This litigation starts, my lord, since my lord, last year, September. Now, my lord, we are coming to another September Puja vacation. So, my lord, if it is to be taken, my lord, the vehicle is standing idle because of no timetable. At present, there is no timetable.
Till this is disposed of, will you continue to apply in terms of the
But the
letter under objection? That is the timetable issued by the authority. Page 66.
my lord, so far as the up trip is concerned, my lord, I have no objection. That's why, my lord, then I have to only the up trip will be, my lord, that only because I will apply the vehicle in terms of this timetable. Because I have no objection so far as the up trip is okay, my lord. There is no problem at all to apply the vehicle on the basis of the up trip. But there is a specific timetable, timing class in respect of the down trip is concerned. With the particular vehicle number has also been given. My lord, the timings are specifically classing with those. At the same time,
For the time being, will you continue with this schedule? Till your objection is disposed of? Yes.
my lord, because the vehicle is standing on a strong.
Whatever can apply.
My lord. Because of the objection, let them
Something should also.
for the timing. Let me allow. Let these objection, my objections be heard out. My lord.
Yes, sir.
That can be done, but my lord, there should be, my lord, the one, my lord, at least there should be a finality to be reached. Now, my lord, if your lordship, my lord, kindly have a look.
Now,
Just
Mr. Sen, what is the reason behind inviting objections from the
there
associations only?
are. I'm coming to that. There are, my lord, because if your lordship kindly, my lord, before that, my lord, kindly come to provisions 119 rule, Bengal rules, lordship.
Of the?
Rule 119 of the, my lord, the West Bengal rules.
Rule 19. So
Yes, 119.
My lord.
Oh.
Yes.
In all cases of disputes in regard of the timetable for stage carriage on a route or area, the decision of the transport authority granting the permit
or of the officer authorized under the rule, that is the secretary president, shall be final. Now, we do not go through the proviso. Proviso is not applicable here. But the main, the contention is, my lord, that is rule 119 is that at least, my lord, once there should be a finality, unless and until, my lord, if it is shown that is it palpably wrong, injustice, arbitrary, or, my lord, the decision-making authority has not applied his mind at all. Here, my lord, there is no such grievance that arbitrary, whimsically, non-application of mind, or, my lord, no authority. Only thing is this, that why the other associations, they have been called upon to produce any paper, or, my lord, how the class-free timetable can be given, the suggestion. Now, my lord, this particular route is, my lord, inter-region route. 2 districts are covered. Now, vehicles coming or permit issued from either Hooghly district or the other district. Now, if it is, my lord, issued by district A, then my lord, the countersigned by B, and if it is B, then countersigned by A. So, my lord, it is not a case that only the petitioner's vehicle are covering that particular area or route. In a zigzag process, my lord, there are several vehicles applying. Now, timetable should be, even for benefit of the present petitioner also, a class-free timetable. That means at the same time, 2 vehicles cannot reach at the same time, at the same point. And now there must be some, my lord, the difference between one vehicle to other vehicle. 5 minutes or 10 minutes, it depends upon the, my lord, the number of vehicles commuting the passengers and the length of the route. Suppose the length of the route is 200 kilometers. Number of vehicles, my lord, not sufficient to cover the entire 200 kilometers within a very short span of period. So there, my lord, the time between, my lord, one vehicle to other vehicle covering a particular distance, a particular area, maybe there the gap may be 20 minutes, 30 minutes. But if the number of vehicles operating on a particular route or area from one point to another, sufficient vehicle, then, my lord, the timing, the gap from one vehicle to other vehicle covering at the same time on a same point, maybe 5 minutes, even maybe 3 minutes, maybe 20 minutes. This is one thing. Another thing is this, that, my lord, everybody want.
This is you are on the clash-free aspect.
Class-free aspect
That
always.
has to be decided by the authority and not.
That has to be decided by the authority.
Not the court.
Now, he may not be satisfied with this timing. That is the problem, my lord, that is his problem. But the authority has to look into the other vehicles which are operating on that particular segment, particular area. They are operating timetable already there.
But that cannot be the association.
Association already, my lord, represent, or say kindly consider, association is a representing body. Association may not be a decision-making, my lord, I think the part of the decision-making process. But the association can, my lord, produce or place, my lord, documents and or papers that how many vehicles are plying so far Bakura, how many vehicles are plying so far other association within this particular segment. They can provide this, let's say, kindly consider, and their timetable. That is why, just, my lord, to help the authority to come to a particular finding that yes, this can be in what time he could be accommodated. This is the thing where I have to place him. If the authority see that this is the time to place him in between, because my lord knows that here there is no such law that first come, first serve. Suppose somebody, my lord, obtained permit 5 years back, somebody 10 years back, and somebody only 5 months back. Then this is not the law that the person who is operating for last 5 years, so he should be on a better timing than that of the person who is now granted the permit. My lord, I have not yet come across any such. So the problem always remain. Even the suppose my learned friend is not getting a particular time today. Suppose tomorrow another permit is given either by the Bankura RTA or by other RTA covering the same segment. Then again, this problem would come that with regard to the timing to be given to that particular, because unless and until, Lordship kindly consider one thing, the total number of permits, that this is the cap, no more permit. Unless and until that is there, if the law permit, then only if the law does not permit, then cannot. So this thing always, my lord, it will be going on. Now, my lord, my humble submission, if your lordship kindly go through this, why their, my lord, their presence are not required. Their presence are not required, that you may be here as a party to the proceeding. No.
They need not be heard.
They only asking the, my lord, may the lordship kindly see the order. Everything is recorded herein. Have you lordship got it, my lord, page 65? This is the impugn. Whereas a permit such and such, my lord need not, then my lord skip it. Then my lord second paragraph. Have you lordship got it, my lord, second paragraph. Whereas dispute against the above mentioned provisional timetable arose and had been solved in the hearing dated such and such in compliance with the order of the Honorable High Court, Calcutta, in respect of WPA number such and such. The two WPA mentioned therein at the office chamber of Secretary RTA Hooghly, and revised provisional timetable for 1 month was issued by memo number such and such, which was amicably accepted by co-transporters of the Hooghly region. Whereas problems occurred among the operators of Bankura region, following which a series of meetings was held with the stakeholders to redress the issue. Whereas timetable were issued to the vehicle of the petitioner by memo number such and such, dated 4th October 21, and that is provisionally for 1 month, and memo number such and such, dated 1st February 2022, provisionally for 3 months, on trial and error basis, to redress the dispute among the operators of Hooghly and Bankura region, but all in vain. And whereas on receiving several objections from the end of the Operators and Bus Owners Association of Bankura District and from the Secretary RTA Bankura region as well against the provisionally issued timetable, these authority further called the stakeholders for hearing on June 7, 2022. But after prolonged discussion, owing to uncompromising mindset of the petitioner, matter was not resolved, resulting which no decision could be taken for redressal of the issue. And whereas as per the proposal of the petitioner, another timetable by memo number such and such, dated August 1, 2022, provisionally for 1 month was issued by this end, resulting which this authority further received several objections from the co-transporters of the Purba Bardhaman and Bankura district due to clash of timetable with the vehicle of the petitioner. And whereas the petitioner, Sri Samrat Beat, filed another writ petition by 2137 of 2022 for renewal of last issued provisional timetable in respect of his vehicle in question, and in compliance with the order of the Honorable High Court dated 26 September 2022, and in connection with the said writ petition, a hearing was scheduled on October 19, 2022 for finalization of timetable of the said vehicle. And whereas the petitioner, along with private respondents and other transport operators of Hooghly and Bankura district, were present in the hearing, and after prolonged discussion, both the parties, that is the petitioner and the private respondents, including concerned association, requested to this authority to allow them all, including the petitioner. Lordship, kindly consider this has not been, it is not their case. No, we were not the party to that request made. Requested the authority to allow them another 15 days for settlement of the issue of timetable amicably from their end, and NGO to submit a class-free proposal for timetable before this authority by 3rd November 2022 for further course of action. Whereas they were unable to reach any conclusion for fixation of class-free timetable, so the Secretary RTA Hooghly further issued notice of hearing is scheduled to be held on 21st December 2022 for fixation of timetable in respect of vehicle in question. And the operators of Hooghly and Bankura were advised to bring a this is Lordship, kindly come. Operators of Hooghly and Pakura were advised to bring a comprehensive report on time of departure of vehicles from their originating end to enable this authority to finalize a class 3 timetable. These are required for consideration. Whereas before commencement of the hearing, petitioner Samrat Bid further filed writ petition such and such, and the Honorable High Court in its order dated December 21, 22 directed to Secretary RT Hooghly to take a decision on fixation of timetable against the vehicle in question. Since the Honorable Court has kindly observed that all the interested parties deliberated upon the issue before the authority on several occasions earlier, no further notice is required to be served upon the parties. It is recorded in my Lord's order. So this is the decision now. After deliberation of all these things, now therefore considering the above facts and circumstances and in compliance with the order of the Honorable High Court dated December 21, 22, this authority examined all the matters afresh and carefully and fixed up the following time series.
No objection because this is pending.
He raised objection every time. There is no end. If my Lord said that that objection is to be gone into, my Lord, RTA has to. Secretary RTA has to. But this objection, he is only, my Lord, the motto is, he is eyeing to that particular, my Lord, that timetable that was issued for him once for 1 month, then for another 3 months as a provisionally. And my Lords note that timetable always provisionally. Nobody can say this is the permanent timetable. He is eyeing to that only, that particular timetable should be, but that cannot be, one cannot say that this is my right. This timetable is my timetable. Timetable is always, that was also in course of this, my Lord, the deliberation or in course of this proceeding for a, my Lord, way out that how a class 3 timetable is to be given. He was given that particular timetable for 1 month provisionally, it is mentioned therein, and then 3 months again. So he can raise objection all the time that anybody can, my Lord, that yes, I am dissatisfied. But my Lord, kindly consider one thing. This is not the, my Lord, the function of the RTA to satisfy the operators with regard to the timetable all the time. My Lord, he has to say, he has to speak that why this timetable, why, my Lord, he is not satisfied. Where is the problem when the gap is there? It is not a case that yes, at the same time, another vehicle is running or plying or stationed therein.
Consider his objection.
Consider, yes, my Lord. But every time, if I go to consider his representation, then I have to the other stakeholders. No, so kindly consider, otherwise the class 3 cannot be unless I consider the other timetable.
Most importantly, other stakeholders cannot be the associations.
That is
Then
my
Lord, kindly indicate that the individual operators.
Yes, they have a right to raise objections. My Lord,
My Lord,
this is
they
your
have
lordship.
said.
On the last occasions, my Lord was of the view, my Lord, on the occasions, my Lord, on the association, they are sending the notice. So your lordship's observation was that your lordship is going to, my Lord, suo moto contempt against them. My Lord, the last another matters of my friends. There your lordship's.
My Lord can indicate that the individual operators, we are not on that, but it is the case that the association as a representing body, they can place the much more, my Lord, that is the, my Lord, I think the records and or lordship, the information, the how many vehicles are plying. So very good, lordship, kindly indicate that association need not be called upon.
Need not be?
But
need not be? I don't know what
hey,
need not be.
English ta bolna baba.
No. What is need not be? My Lord, I don't know, my Lord, what the let my I have a, my Lord,
I do not know what is his prayer.
No.
Let him make
This
his prayer.
no, my Lord, this portion I have already, my Lord, I have, you know, Rosif kindly directed to consider my objection.
The existing operators need to be heard.
Yes, my Lord, the operators, if they have any objection to that timetable, my Lord, unless there is no objection, they cannot invite them.
I have to. Otherwise, how can I know?
No, unless the operators are, my Lord, kindly appreciate. Unless I operate the vehicle, there is no questions of raising the objection. If I keep my vehicle aside,
What is
now
the time of
comes
submission?
only when this.
Then, my lord, if I, my lord, issue that, then tomorrow 20 matters would come before your lordship.
Or it has again to be issued provisionally in that case.
If
That
there is any
that
objection,
is not the purpose.
so my lord, that objection to be heard.
Objection is to be invited.
My lord, the law is not there. The objection is to be invited by the authority.
This has to be served
To whom?
to the operators, existing operators.
My lord, let them serve to the existing operators. I am not on this. I am,
leave it.
yes, man, I am.
leave it.
My lord, let them serve the notice to the individual operators.
Only thing is that, my lord, then that in case of a representing body, one notice, one person, and in case of operators, then maybe 20-30%. That is the whole difficulty. But the
That is
the purpose,
There are other aspects to it.
there are other aspects. I leave it to your lordship. Only thing, my lord.
I do
The-
not want to.
I only, my lord, place the procedural aspect.
And my the
But
rules
not
are
the other.
altogether different.
Cannot be equated with the association. Always.
That may be. All may not be member.
That's why I'm insisting.
Yes,
on
yes,
operators,
yes.
not
That is
the
that's the reason. That's the reason. My lord. Oh no, সবাইকে চা বিস্কুট খাওয়াবে দিয়ে খাও
There has been
যে
a series of litigations
যে অবজেকশন করবে যে আমাকে এটা দিলো কেন
with the
সেই চা
parties
বিস্কুট খাওয়াবে
with regard to issuance of clash-free timetable in favor of the petition.
ও হয়ে গেল গল্প শেষ হয়ে গেল গল্প শেষ চলো
In earlier petitions filed before this court, the concerned authority was directed to issue such clash-free timetable in favor of the petitioner upon considering the applications submitted by the petitioner before the authority in this regard. In the hearing held by the authority, both the petitioners and the existing operators
এটা একটা দুটো না এটা মানডে
the petitioner existing operators and the existing operators sought accommodation for settlement, for amicable settlement of the issue. For amicable settlement of the issue. Since no such amicable settlement could be arrived at, a further hearing was called by the Secretary, Regional Transport Authority, HON'BLE,
করিয়ে দিচ্ছে ওই জন্য কোথাও পাবে না কেউ পাবে তুমিও পাবে না আমিও
with a request
যখন
to the operators
তুমি এই কোর্টে দেখতে পেলে
to produce a comprehensive report on the time of departure of their respective vehicles from Tarokeshwar towards Bankura, along with copies of timetable. Finally, the concerned authority, comma, by a letter issued on 16th January 2023, comma, fixed up a timetable against vehicle number W17N and for nothing. 2530. This is your vehicle
Man.
belonging to the petitioner. Which was valid up to 30th June 2023. Being aggrieved by the said timetable, comma, the petitioner submitted an objection before the concerned authority on 30th January 2023. Requesting modification of the same. Stop. The said objection is yet to be considered. Stop. The petitioner pays for the direction upon the authority to consider the objection and issue timetable. Issue a clash-free timetable in favor of the petitioner in order to enable the petitioner to ply his vehicle in the route in question effectively. It is submitted on behalf of the respondents. On each occasion, objection was on each occasion, a notice of hearing was served upon the petitioner as well as the association comprising other operators, existing operators, comprising existing operators of the route in question. And since no amicable settlement was arrived at between them, comma, the authority by an order passed on 16 January 2023, comma, issued a clash-free timetable in favor of the petitioner. Stop. Paragraph. Upon consideration of the submission made on behalf of the parties and material on record, comma, this court is inclined to hold that since the petitioner has filed an objection against the timetable issued in his favor, the day letter dated 16 January 2023, comma, the objection be dealt with and disposed of by the concerned authority, comma, being the authority upon hearing the petitioner as well as other existing operators of the route. Paragraph. Accordingly, the petition is disposed of directing the who should be the authority? The secretary? Secretary will be the fourth respondent to consider and dispose of the objection submitted by the petitioner dated 30th January 2023. 30th January 2023. Within 1 month, Mr. Sen?
My lord.
Within 1 month?
Within, yes.
within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to the petitioner and the existing operators of the route, comma, in accordance with law. Paragraph, the decision taken by the
Existing interested operators. Otherwise, my lord, how many operators?
existing interested
Yes.
operators. Would that be so?
And my lord, these, the decisions
Taken by the authority.
which has been already, my lord, in respect of this timetable which has been given, my lord, lordship, because the vehicle is standing, I will be permitted to ply the vehicle on the basis of the permit which, timetable which has been, that has to be.
The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph, pending disposal of the objection, comma, the petitioner is at liberty to ply his vehicle
Yes.
in terms of the timetable issued in his favor on 16 January. 2023.
On 16th of January.
16 January.
Mine.
Without prejudice to his right.
Yes, yes.
Without prejudice.
Without
to his
prejudice to his right.
rights and contention.
Mine.
Without prejudice to his rights and contention.
Mine.
Disposed of. which are-
Get.
Hearing notice.
Number.
131. Hearing matter 131.
Before your lordships take up this matter, next matter is mine.
Yes.
So, my lord, I understand Mr. Siddiq will continue till 4:30. I talked to him.
I'll continue till half an hour, I will at least take, but not less than that.
Huh?
For 35, 40 minutes.
Oh,
I'll just conclude my,
It's already,
I'll conclude my argument today.
No, পুরোটা চালাবি না তো?
না হয়ে যাবে 4:15-20 হয়ে যাবে করতে করতে।
Item number 29, which is
আমাদেরটা
also
বলছি।
330 fixed. That is also there, my lord, we had mentioned.
difficulty, 330 fixed matters,
Yes.
330 matters. Now what do I do?
Next matter, Mr. Sengupta is continuing his argument. Next matter. So, my lord, let the marking be there. Only I am requesting this thing.
Well, may it be taken up tomorrow in that case, my lord.
Which matter?
Item number 29, which is also 330 fixed.
29.
29?
29.
29.
Excellent.
Excellent, my lord.
But I appear for the respondent.
My lord, we had concluded our arguments, but if your lordship wishes, my lord, we can refresh your lordship's memory.
Right.
Yes, my lord. And then Mr. Dotto has to, my lord, respond. We had concluded, but we'll, my lord, we'll summarize and, my lord, refresh your lordship's memory. Short point, my lord.
Let it remain. Let us see. Let it remain in the list. Let us see.
Well, the interim order is also there, which expires at the end of the month, but we'll,
So we have some time.
yes, my lord.
These matters will be taken up tomorrow once again. The 330 matters, like the one Mr. Mukherjee has mentioned.
If I reach, I'll call.
Well.
It's difficult to say like this. I mean,
Only thing, my lord, only thing is this, my lord, that we are requesting, my lord, lordships, my lord, that let the marking be there. Or that is,
330 marking.
yes, my lord, that is the prime consideration for us. Because Mr. Sengupta is verge on this completion of the, or this statement, then, my lord, Mr. Dotto will also.
Where is it?
You can never say.
No, my lord, this matter will continue. Today is not possible.
But Mr. Sengupta doesn't know that this will continue.
না 131 টা
আমি যে petitioner
ওটা সিদ্দিকী বলছে এখন চলবে ওটা
আজকে শেষ করব
আজকে ওরা বলবে না সপ্তাংশ রিপ্লাই দেবে তারপরে
My lord, we are ready, my lord, in as far as 29 is concerned.
Let one of the matters be made not this week in that case, because again, both the matters appearing at 330 tomorrow will not really help.
so my lord, may I say suggest in this way, my lord, my matter will be taken up on next Wednesday or Monday as your lordship.
Let your matter be made not this week.
My lord,
So it will appear on Monday or.
yes, so my lord, আবার একই কথা বলছো কেন
আরে ওর কথা
আরে ওরটা কালকে করে নাও তাহলে তো কনফ্লিক্ট ইয়ে হবে না
Kishore Das has to give the reply.
Tomorrow.
Kishore Das convenience.
You have some difficulty tomorrow.
No, I don't have any.
so tomorrow we do it.
It's in both the matters, na.
Maybe the second matter to not this week. Kore rao.
Yes, but 330 marking may be there, my lord, lordship guide.
Nothing else will change.
My lord, my lord.
Our issue change হবে না কারণ not.
My lord, tomorrow I'm told, my lord, there'll be original site, my lord, the second half. So, my lord, maybe it's on
Wednesday after it will come.
the day after.
Day after is a group 7 matter.
Then, my lord, Monday, if your lordship, my lord,
Then
if you
Monday.
can. Oh, Monday.
Next week,
My lord, next week, Wednesday, my lord, in that case, my lord. But we'll try our luck, my lord, and get the matter heard out, my lord.
The matter has not been called, that's the difficulty.
If it is marked.
My lord, mark 330, my lord. Your lordship will just, and both of us are here. my lord.
Monday week,
Monday week.
we item 29 ta korun, by consent of the parties, let the matter appear under the same heading on 24th. Rajiv, 24th, marked at 3:30.
24.
Marked at 3:30.
My lord, may I request if it's at 3 o'clock, my lord?
কিন্তু এটা যেহেতু বড় হচ্ছে, then it is special fixed time.
হবে না 3 o'clock হবে না 3:30 থেকে গ্রুপ 1 না ওটা মোশন থাকে তো
তাহলে ওরা mention
আবার hearing।
তুলে নেবো আমি ফাইলে থাক মানে লিস্টে থাক মার্ক করে 3:30 রাখুন, তাহলে আইডেন্টিফাই করতে সুবিধা হবে।
24. 24.
এটা সোমবার দিনকে হবে No, Mr. Sengupta will continue. No, Mr. Sushovan Sen will let him.
He wants to be there, so then there be another. It could be Wednesday instead of Monday.
Then make it Wednesday.
By consent again.
By consent, can you next Wednesday? Can it?
Rajiv, next matter. 132 ta korun. By consent of the parties, the matter is, by consent of the parties, let the matter appear under the same heading on Wednesday is 19th. 19th July.
Mark as 3:30.
19th কোনো অন্য 3:30 আছে কিনা একবার check করুন।
3:30 সবই রাত।
Again, the same difficulty will arise.
Yes.
My lord, your lordship's pleasure will be to fix it at 3:30 only, not at maybe 3 o'clock. Possible.
Okay, here the other matters also, isn't it?
But this has been heard substantially by your lordship.
Several matters have been heard substantially, sir. Cannot be held.
I
এখনো কিছু নেই। Marked at 3:30.
Deeply obliged to us.
Next Wednesday হলো, তাই তো?
Next Wednesday.
24 তারিখ।
132.
So many other matter may be released today. Yes. হ্যাঁ, সিদ্দিকি চলবে। চলবে তো?
We'll continue for 45 minutes.
ঠিক আছে, চালিয়ে যাও।
করো তাহলে সাথে মতো করে।
The petitioner?
My lord, I am a
You're a petitioner.
Should I kindly recall, my lord, this is with cancellation, with regard to cancellation of the lease deed, which was originally executed by and between the state of West Bengal and the West Bengal Social Welfare Board. The objective of giving this particular land to the West Bengal Social Welfare Board was for the purpose of constructing a working women's hostel. Now, my lord, subsequently, after getting the lease, the West Bengal Social Welfare Board, I'll take a minute. Now, my lord, subsequently, the West Bengal Social Welfare Board, without taking any prior permission from the state authorities, they floated an advertisement and had allotted the land by virtue of a development agreement in favor of the writ petitioner in altogether different capacity, as in a, the condition was, it was a PPP model, private partnership, public-private partnership model, PPP model. Now, my lord, the objective of setting up a women hostel, the objective of the state for giving it to West Bengal Social Welfare Board, the West Bengal Social Welfare Board had diluted that entire objective by giving it to a private entrepreneur, not by calling for tender, not by taking permission from the state, because the law clause of the lease deeds was exclusive But I've shown you your lordship on the last occasion, I'll not reiterate the same point. The clause of the lease deeds were exclusive, that one has to abide by the conditions of the tender, that it has to be strictly given for the purpose of setting up of working women's hostel. My lord. Thereafter, my lord, it was also provided in the lease deed that in case there is any breach of the obligations of the covenants of the lease deed, then the state, the concerned department of the state has the right to seek cancel the lease deed and take back the possession of the land. Now, subsequent, my lord, after coming to know about such fact that this particular land has been given, allotted to this private entrepreneur, my lord, the West Bengal Social Welfare Board was directed by the Urban Development Department of the state as to how you have given such allotment. As a sequel to such, my lord, I'm not troubling your lordship with all these advertisements because time and again these are being placed. As a sequel to such notice given by the Urban Development Department, the West Bengal Social Welfare Board issued a notice to the petitioner company seeking to cancel the agreement. Will kindly grant me a minute's time. Kindly bear with me. My lord, it is appearing at page 138 of the writ petition.
Of the writ petition.
Of the writ petition.
Yes.
My lord, this is the letter issued by the West Bengal Social Welfare Board on 25th of February 2016, addressed to the director of the petitioner company. And the subject is regarding cancellation of the development agreement made on 9th September 2013 between the West Bengal Social Welfare Board and Mrs. Tarabashon Limited. Page 138, a short. Social Welfare Board cannot go against the conditions stipulated in the lease deed. The land was specifically allotted. All the relevant clauses of the West Bengal Social Welfare of the lease deed has been mentioned in the next page of the communication. If your lordship kindly sees page 4, in the said lease deed is categorically mentioned in paragraph 7, clause 4, you have lordship is saying that the lessee shall not subdivide or sublet the demised land or the building to be constructed without consent in writing from the government first hand and obtain, and government shall have the right to be entitled to refuse this consent as is absolute discretion. Now, my lord, shall not subdivide or sublet the demised plant. My lord, the West Bengal Social Welfare Board was given the land that you engage someone, construct a working women's hostel for these working women. They have gone a step further. Not only they have given it to the private entrepreneur to construct a hut called Banglar Hut, they have also taken the power to sublet other floors of the premises. The building which is to be constructed, they have also taken the power. If your lordship kindly comes to, but I'll just take your lordship to the development agreement, which is appearing at page 62 of the writ petition. It starts from page 58. Lordship kindly sees the covenant. It is not that the West Bengal Social Welfare Board or the petitioner company were not aware of the lease deed. The Lordship kindly sees page 62, clause B. The Lordship got that.
Yes.
The said land for setting up the Bongo Hut, working women's hostel, and other families' residential accommodation is allotted by the West Bengal Social Welfare Board by the government of West Bengal. Possibly they were meant to, they wanted to mention is allotted to the West Bengal Social Welfare Board by the government of West Bengal. Well, nowhere in the lease deed, I'll take your lordship back again to the lease deed. Nowhere in the lease deed, it is for family accommodation. It is for hostel only. And thereafter, my lord, with the right to sublet, assign, make construction and dispose of. My lord, time and again it has been, my lord, submitted by the learned counsel for the petitioners, for the petitioner, my lord, that the West Bengal Social Welfare Board, being an alter ego of the state, has entered into an agreement with its eyes wide open with the petitioners. And when they have made certain promises, then they are bound by such promises. So, my lord, a question has arisen that they are now stopped from making the allegations that the petitioners cannot be faulted for the wrongs committed by the West Bengal Social Welfare Board. Well, that is the whole crux of the argument by the learned petitioner.
Because the lesser and the lessee are the same body.
The same.
It is also
Now, my lord, West Bengal Social Welfare Board is a body constituted by the state. It has its own formation. It runs with some 50% grant given by the central government, 50% grant given by the state government. Now, the West Bengal Social Welfare Board is represented by the same council before a lordship also. But a wrong, an illegality which has been committed by a board at any point of time, which comes into the notice of the state, and that to a welfare estate, I put this question to myself, whether that illegality can be allowed to be perpetuated. Well, this is a state largesse. So this is a state largesse. And being an officer of the court, I take this responsibility upon myself that those persons of the Social Welfare Board who were responsible at that point of time in entering into such development agreement, though I do not have any detailed section in this regard, they should be put to task. But an agreement which is entirely founded on illegality, which is opposed to public policy with regard to grant of state largesse, can that agreement, my lord, can be allowed to stand? That is the moot question which I put to myself. My entire submission is based on this aspect only. My lord, I need not trouble your lordship with the entire, because it is glaringly evident from all the documents that the lease deed was for a specific purpose, and that was a welfare purpose. They have diluted the condition of the lease deed from a social purpose or a welfare purpose to a commercial purpose. Now, if your lordship kindly sees the development power of agreement also. Power. It is at page 103.
Power of attorney.
This is the power of attorney for the purpose of construction of the building. This is development power of attorney. This is development power of attorney. Now, if your lordship kindly comes directly to page 114, which is the part of the power of attorney, internal page 11 of the said registered development power of attorney. Page 114. Running page 114. It is internal page 11 of the development power of attorney. Lordship kindly sees clause 24 of the development power of attorney. To ask, receive and realize from all occupiers or transferee, sublessee or transferees, sublessees of flats, units, shops, car parking spaces and other areas charges, expenses, rates, cesses and other sums due or that might become due and payable by him, her, it, them and on payment, take approved steps for realization thereof pertaining to developers allocation. My lord, they can give it to occupier. They can collect all those rents from the flat owners, unit owners. My lord, this was entirely illegal. Now, my lord, now coming to back to this writ petition, my lord, one thing which has been showed time and again to your lordship is the award passed in an arbitration proceeding. The award in an arbitration proceeding between the petitioner company and the West Bengal Social Welfare Board. Because the letter which I was placing reliance upon, which was at page 185 possibly. পাতায় ছিল রে ওই লেটারটা কাগজটা কোথায় গেল না তোদেরকে at page 138 regarding cancellation of the development agreement. Lord, I took your lordship back at page 139. I took your lordship back to these paragraph 7 because I wanted to demonstrate before your lordship that through this sublease, my lord, they were trying to subdivide the property, sublease the property. They could not have done so. They could have assigned some work order to any developer to construct the building and they should have paid for that construction work. Thereafter, in paragraph 9, paragraph 5 of the said letter, in paragraph 9 of the said lease deed, it is also mentioned that not to use or allowed to be used the land and or structure thereon or any part thereof for any purpose other than for construction of hostel building for working women's without the prior permission in writing of the government or the authority prescribed in that behalf.
This is page 139.
139, my lord, the fifth clause. My lord, all the paragraphs of the lease deed has been mentioned.
Yes.
Paragraph 7, I showed to your lordship and I took your lordship back to the development agreement and the power of attorney. In paragraph 4, paragraph 7 of the lease deed has been mentioned.
Yes.
Similarly, in paragraph 5 of this correspondence, paragraph 9 of the lease deed has been mentioned. Paragraph 6, paragraph 10, all this has been mentioned. Well, I'm not troubling your lordship with the entire contents of this letter. After this letter and the subsequent letters, my lord, which is appearing at page 140, my lord, the petitioners immediately rushed before the learned district judge at Barasat under section 9 of the Arbitration Act. And thereafter, my lord, an arbitrator was appointed and thereafter in the arbitration proceeding, an award was passed. The next page, if your lordship kindly sees. And the award is at page 173. I'll not trouble the entire arbitration proceeding. The award of the arbitral tribunal is at page 173. 173. 173. Now, my lord, this award is binding, my lord, upon the West Bengal Social Welfare Board. This award has been passed upon the West Bengal Social Welfare Board to act in terms of the agreement dated 173 is the award of the tribunal. Act in terms of the agreement dated 9 September 2014, read with agreement dated 20th August. This is a development agreement. 9 September 2014 is a development agreement. And 20th August 2014, Modified agreement. 20th August is the development agreement, 9th September is the modified agreement. Modified agreement. Development agreement was modified and certain more powers were given to the petitioner company. Particularly, my lord, can I take your lordships just 30 seconds of your lordship and just sip some water and come back? Extremely grateful. I'm sorry, I'm extremely grateful. My lord. Award of the tribunal. Award is passed directing respondent to act in terms of the agreement dated 9 September 2014, read with agreement dated 20th August 2014, particularly in obtaining permission from the government of West Bengal in terms of clause 6.2 of the agreement dated September 9, 2013. But my lord, to act in terms of the agreement so and so I could understand, particularly in obtaining permission from the government in terms of clause 6.2. Well, till date, no such permission has been granted. An award for perpetual injunction is passed, restraining the respondent from giving any effect or further effect of the letter dated 25th February 2016 and the undated letter, those two letters which was which I had just shown to your lordship, written by the West Bengal Social Welfare Board. Now, my lord, after this, the petitioner's content, even after the this arbitral award was passed, the West Bengal, the Urban Development Department, my lord, the Urban Development Department sought to put up a placard in the land in question. Immediately thereafter, they had written a communication on 3rd of August 2017, which is at page 175. This is the last annexure to the writ petition. Page 175, saying that there is an award in our favor, so we have the right over the land, and challenging our action of after giving this demand of justice of 3rd August 2017, they filed the instant writ petition before this honorable court. Now, my lord, the relief sought in this writ petition. The lordship kindly comes to the prayers of this writ petition. At page 32. But page 32, as the lordship got that. The relief sought in this. The annexure which I just showed to your lordship is the last annexure to the writ petition. And the relief sought in this writ petition, it starts from page 32 of the writ petition. The prayers.
Yes.
Prayer A is the writ of certiorari, asking for the record. They are asking to produce the records of the case, which led to the purported circular memorandum notification by which the respondent number 2 had put up a signboard upon the said plot. This certiorari. Prayer B is mandamus, not to take any steps from removing to remove the signboard from the said plot and not to disturb or disrupt and cause hindrance. And the prayer C, which is most important, a writ of and or in the nature of mandamus, commanding the respondents, each one of them, their main agents, assigned subordinates, thereby setting aside and not quashing any order and or decision taken by the respondent number 1 and 2 to resume the said plots of land, being plot number so and so, by cancelling the lease deed dated 20th August 2013 and to repossess the said plots of land, and in the alternative to command the respondents to forthwith recall, rescind, withdraw the purported order and a decision taken by them to resume possession of the said plots. Now, my lord, we have already, my lord, during the argument of this writ petition, we have already disclosed before this honorable court that we have already cancelled the lease. Now, my lord, the most important question now arises in connection with prayer C in the writ petition. that the lease deed is executed between the state of West Bengal and the West Bengal Social Welfare Board. They are not a party to that contract. They are not privy to that contract. And the West Bengal Social Welfare Board always had the right in terms of, or the West Bengal government, the Urban Development Department of the government, always had the right to cancel the lease deed if there had been any violation of the terms or clause thereof. It is not the case of the writ petitioner that the lease deed has been cancelled or attempts to cancel the lease deed was made in derogation of the clauses mentioned in the lease. It is not the case of the writ petitioner. Now, my lord, after coming to know all these facts, we have cancelled the lease deed. There are numerous supplementary affidavits filed in this writ petition. One such supplementary affidavit, which is of
3rd of July, 2018.
20th July, 20th July 2018, page
13 কি তোমাকে হারিয়েছিল তোমারটা বলেছিল কপি দিবি
My lord, Lordship has got that 20th July 2018 or 3rd of the third copy.
But you are going to refer the page.
Na page, এই page টা দরকার আছে। 3rd of July 2018, তাই তো?
Supplementary তো।
This is 3rd July.
There is one correspondence because what has happened, there were so many supplementary affidavits and one or two supplementary affidavit was directed to be ignored by this honorable court. So all papers are mixed up. All papers are mixed up. And
sorry to interfere, my lord, if my learned senior friend is referring to the prayers in the supplementary affidavit. Oh, you're not referring to the prayer.
Annexure I refer করছি। Annexure পাতাটা মিলছে না বলে বলছি। তুই তো মানিস চলে।
Page বলো।
এই তো একটা 24 নম্বর পাতা আছে। Lordship has a supplementary affidavit of
3rd July.
My lord, it will be 20th July 2018.
20th July, let me go.
20th July 2018. Acha. Lordship got at 20th July 2018. It is the supplementary affidavit filed by the petitioner.
My lord, this is the second supplementary affidavit.
I just find that. 20th July 2018.
My lord, your lordship, can you take directly page 24? Page 24 is the communication by the Urban Development Department to the, has your lordship got that communication dated 16th January 2017?
Yes.
My lord, this is the communication with regard to cancellation of the lease. This is the communication with regard to cancellation of. I'll not trouble your lordship with the entire communication. Page 25, the last paragraph at page 25. So the violation has been mentioned in the entire communication. Because this matter is going for since many days, man. I just want to finish it off. My lordship, kindly see the last paragraph. Now, therefore, after careful consideration of this matter, the governor of the state of West Bengal is pleased to determine the lease of the plot number so and so under clause 4 of the aforesaid indenture for violation of clauses so of the lease deed and re-enter into possession of the demised land. So basically, my lord, after this cancellation of the lease deed, when steps were being taken to re-enter into possession of the demised land, because the lease deed was cancelled on 16th January 2017, and the boards were affixed after that. On 3rd of August 2017, my lord, they filed a representation which is at page 175. On the ground that we have attempt is being made to evict us from the premises, and some signboard has been affixed at the premises, And thereafter, this writ petition was filed. But in fact, long back, on 16th of January 2017, the lease deed was cancelled. Now, my lord, a prayer has been made now in the writ petition that if any lease deed has been cancelled, then the same should be rescinded. Though the petitioners are not privy to that contract between the state and the West Bengal Social Welfare Board, but the petitioners have no challenge in this writ petition. The entire crux in this writ petition is the cancellation of the lease deed, which they do not do directly at the time of filing of the writ petition, but they say that after filing of the writ petition, subsequently they came across these communications and they filed a supplementary affidavit annexing all these documents. No, these are the. I do not. I don't think the petitioners have any case against the state respondents, my lord, in this particular case. But they want to demonstrate before your lordship at this juncture that they have a case with the West Bengal Social Welfare Board because they have acted upon their promise. This was a contract, and based on the promise, they have acted upon it. So, and West Bengal Social Welfare Board, being an alter ego of the state cannot shrug off its responsibility of with regard to the obligations of the West Bengal Social Welfare Board in the development agreement. Now, my lord, the West Bengal Social Welfare Board has subsequently, after filing of this writ petition, has filed an affidavit in this in connection with the writ petition. The affidavit in opposition on behalf of the respondent number 4.
Yes.
My lord, if your lordship kindly sees, these entire affidavit is not it has not dealt specifically with all the paragraphs of the writ petition. I'm being very candid to your lordship. This affidavit has not dealt specifically, it is more in the form of a report. I was going through the entire affidavit, it is more in the form of a report. Now, my lord, if your lordship kindly sees from page 2 onwards, my lord, how the West Bengal Social Welfare Board has come into being has been mentioned from paragraph 2 onwards. The Central West Bengal Social Board was formally incorporated with Registrar of Companies under section 25. The state social welfare boards, like the West Bengal Social Welfare Board, as well West Bengal Social Welfare Advisory Board under the government of West Bengal, previously relieved, was set up in 1954, 1955 in all the states and union territories. The expenditure of the West Bengal Social Welfare Board establishment budget is met on 50-50 basis by the state government and the Central Social Welfare Board. As your lordship, mark that much. The expenditure is borne by the state government and the Social Welfare Board. Page number 2 of the affidavit in opposition. My lord, thereafter, my lord, how this all came into being, the lands were being sought to be allotted, money was allotted, everything has been mentioned. From paragraph 4 onwards, through a memo bearing number so and so, the government of West Bengal in the Relief and Welfare Department informed the Accountant General, West Bengal, that a sum of rupees 1,28,000 was sanctioned with conference of the, it was as long back as 1977, towards cost of 4 plots of land. Then paragraph 5, the Chairman West Bengal Social Welfare Advisory Board placed the fund of rupees 1,28,000 being the cost of land for construction of a working women's hostel. All these are annexed, my lord. I'm not troubling your lordship. All these are annexed. My lord, thereafter, by the next communication, my lord, it all started from 1977 onwards. And always the avowed objective was to set up a working women's hostel. But then after paragraph 6, by a letter number so and so, the chairman, West Bengal Social Welfare Advisory Board, informed the executive engineer that the said amount of rupees 1,20,000 was drawn and deposited by the Director of Social Welfare Board to the Reserve Bank of India towards cost of 4 plots of land measuring 4 katas each. Then my lord, again, Bishop Lordship kindly skips paragraph 7, then paragraph 8. Thereafter, by writing bearing number so and so, the government of West Bengal in the Relief and Welfare Department again informed the Accountant General that a sum of rupees 1,28,000 was sanctioned towards cost of 4 plots of land measuring 4 katas each. At that point of time, 1979, 1,28,000. Now, my lord, the next page also, the plots change, that this plot may be taken, that plot may be taken, and the amounts also, time to time amounts was sanctioned. I'm not troubling your lordship with the entire thing. Thereafter, some meetings of the Social Welfare Board was taken place, where it was decided the land will be allotted only for the construction of working women's hostel. If your lordship kindly sees paragraph 18 at page 10, there was a meeting as long back as in the year 2007. From agenda number 6 of the minutes dated August 17, 2007 of the meeting of the board held on July 2, it appears that the board had made several correspondences with the Urban Development Department, Government of West Bengal, seeking terms and conditions for registration of those plots. Subsequently, a discussion was held with the department where they apparently agreed to construct a 4-story building, clubbing the 4 plots and to name it Samaj Kalyan Bhavan, where all the wings of the Social Welfare Department, including the Working Women's Hostel, could be accommodated. All these were contemplated, all this would happen. Thereafter, at paragraph 22, my lord, at page 13, upon execution of a registered lease of deed, that is the lease of deed which has been cancelled, dated August 20, 2013, by and between the governor and the West Bengal Social Welfare Board, the said plots of land so and so was leased out to the board on terms and conditions contained therein for the purpose of construction of hostel building for working women by the board, and the same was intimated to the Department of Women and Child Development and Social Welfare. In clauses number 7, 9, and 10 of the said deed of lease, there was specific directions not to subdivide or sublet, not to use or allow, no right of creating. Delivery of possession, my lord, in the next paragraph was made over to the Social Welfare Board on October 30 with a position certificate number so and so. My lord, thereafter, even the Central Social Welfare, paragraph 25, with a F number dated March 4, 2000, Central Social Welfare Board granted no objection for construction of women's hostel and Bongo Hut, a platform of women for self-employment. But this also has been sought to be diluted. The Bongo Hut, the petitioner says, is like setting up the market for the petitioner's own welfare. They will allot the land, transfer the shops for some. It was only for generating or encouraging women empowerment, so that unskilled laborers or skilled laborers may work there. Had already even the Central Social Welfare Board had granted them no objection. Subsequently, West Bengal Social Welfare Board executed the following 3 indentures. The aforesaid agreement, paragraph 27, the stand of the West Bengal Social Welfare Board. Here, my lord, in paragraph 26, the West Bengal Social Welfare Board itself in its affidavits admits, yes, I have entered into a development agreement with modification, development power of attorney. But at paragraph 27, my lord, I say, my lord, that I am guilty of entering into such agreement. I say the West Bengal Social Welfare Board says that the aforesaid agreements were executed without any tender for construction and development of multi-storied building with basement parking for providing building and the ultimate roof for residential and other purposes, which would be the sole property of the developer. That is the developer's allocation. And with the further right to transfer and mortgage, the aforesaid agreements were executed in utter violation of the terms and conditions of allotment as specified in the original deed of lease and without any permission from the concerned departments of the government. Opposition of respondent number 4. Possession of the land in question was already also handed over to Mrs. Tarabashan and they started construction thereon. Also deposited a caution money, my lord, this is also admitted, of rupees 30 lakhs and an earnest money of rupees 5 lakhs, which is still lying deposited in the bank. That is their money. My lord, they are entitled to that money. They can very well take back that money, but they cannot insist upon the West Bengal Social Welfare Board or the state authorities. No, you have allocated that land to me. You please allow me to construct a multi-story building thereon on commercial basis of PPP model. The board with a letter number so and so dated so requested Mrs. Star Abashun to submit their claim as the board was going to cancel the aforesaid 3 agreements. As the aforesaid 3 developments agreements violated clauses so and so of the original lease deed, the Urban Development Department issued notice on January 4, 2017 to the West Bengal Social Welfare Board in terms of clause 4, calling for explanation as to why the plot shall not be resumed. After hearing, the government of West Bengal in the Urban Development Municipal determined the original deed of lease dated August 20, 2013. But I have nothing to hide. I have nothing to suppress.
The board wakes up subsequently.
I have nothing to suppress before your lordship. Wrong has been committed, but that wrong cannot be allowed to be perpetuated. That illegality cannot be. My lord, I just conclude my agreement with this submission. And on the next day, my lord, because we are running short of time, I'll just rely upon, I will not make any further argument with regard, because these are all facts which are before your lordship. I cannot suppress any fact. The West Bengal Social Welfare Board has gone beyond the main conditions for which the lease was granted. I'll just rely upon 4 or 5 judgments, my lord. I'll tell you, lordship, with regard to legitimate expectation, with regard to promissory estoppel, because they may always take a plea. There is, since you have promised and I have acted upon your promise, you have stopped from making any further. They have taken that point. So with regard to promissory estoppel, vis-a-vis state largesse, and with regard to public property, how the public property should be dealt with. But I have 4 or 5 judgments. I'll just place lines upon. Lordship may kindly fix a short date. Well, I'll come and I'll not make any further argument with regard to this. After that, they will give the reply. I'll just place lines upon the judgment. On Monday.
This Monday. This Monday.
No. I've already fixed a matter this one.
Any dates, if it suits your option.
Third learned counsel for the respondents. Paragraph, let the matter appear under the same heading for further consideration. 24th. 24th.
Any date.
24th. রাখলাম একটু জিজ্ঞেস করতো। I've fixed other matters also. Maybe 24th এ রেখেছি কোনো matter?
24th আগের ম্যাটারটা রাখুন।
না 26th এ রাখলাম।
না 24th।
26th এ কিছু আছে? Hearing.
এটা আছে।
এটা কি?
আমরা সব দুটোই রেডি আছি।
17th, 19th দুটোতেই আছে।
Maybe on 19th, my lord. And then 19th.
শুক্রবার।
No.
Monday.
ফার্স্ট সিগনেচারটা দিলেন। ওইটা দিয়েছেন 24th এ। 29 আজকে আছে। ইনভেস্ট যেটা আপনি দিয়েছেন সেটা দিয়েছেন
26th এ আগেই আছে বলছি।
26th এ আছে। আমি 26 এ এখানে কোনো ডেট আমি দেখতে পাচ্ছি না। টাইম কিছু দেখছি না। অর্ডারে
That would be on 26th.
26th.
Lord may kindly fix that's the first hearing matter, my lord. Because they have been, my lord, complaining that my lord, because of me, this matter has.
No,
So, my lord, I want to conclude this matter.
26th, huh?
Kindly first,
At
kindly
3:30.
first hearing.
3:30.
26 তারিখ না? কটার সময়? ঠিক আছে দাদা আছে চলে আসবে 5 মিনিট। আছে তুমি দিয়েছো আমি রাখবো না, হতে পারে গালাগাল দিলেও আমি তুলে রেখে দেবো।